This is
supplement my user. Agenda item 1, apologies. Both Danny and Patsy have apologised. Any other apologies from anyone? Someone? Okay. No other apologies? Okay, agenda item 2 then, draft minutes of the 14th of January, pages 6 to 13 of the meeting folder. If members just want to quickly glance over those and indicate if you're happy enough for me to sign the minutes. Everyone content?
Yep.
Thank you. There you go. Thanks. Matters arising then, just following the informal budget briefing, are members happy enough if we forward on that paper to the department for response?
Agreed.
Excellent. Okay, then forward work programme for February to March, page 15 to 22 of the meeting folder. The department's advised that the SL1 and victim statement regulations, which was due to be considered today, has been postponed indefinitely, as the Attorney General has raised a number of issues which warrant further consideration. The Chief Inspector of Sagini has indicated he intends to publish a summary report on the follow-up inspection of Maghaberry Prison at some point in February, and an oral briefing session will be scheduled once the timing of that report is completed. On the committee visit to the Glasgow Drugs Court on Thursday the 11th of February, there's a programme that's proposed at page 23 of the meeting folders, if ever want to have a look over that, if you're content with that. And if members who wish to go, just let the committee staff know that they're available to go to that. Item 4 then was the committee trip to Red Hook. There was only 3 of us on that. I thought it might be useful just to highlight some of the things that we did there. There was a number of meetings. We went to Brooklyn Treatment Court, which is a drugs court in Brooklyn. We went to the Red Hook Justice Centre, which is the part of Brooklyn, the southern part of Brooklyn, that had a real issues in the 80s and 90s, and they brought that community justice court there. And we also went to Brownsville to see the community justice centre that they're proposing to build there as well. They're in the early development stages, but again, they want to do something there. We met with Judge Ferdinand, who runs the Brooklyn Treatment Court. Originally, she was one of the pioneers in this sort of stuff and problem-solving justice. She was the original judge in Miami-Dade, dealing with their heroin addiction and crack cocaine problem in Miami in the 90s, and then moved to Brooklyn. Judge Calabrese we met as well, who is the guy who has run Red Hook since it opened in 2000. He's been there now for 16 years, very much integrated into the community there. And then we went to the Centre for Court Innovation and discussed domestic violence courts with people there as well. So there is documentation that we have come home with from all of the areas and people we spoke to. So if anybody wants a copy of that, just for their own information, we can certainly get that photocopied and made available to them. I think the striking thing was the impact that this kind of community justice has had in the areas where it operates, and the massive impact that mandated health programmes have in actually helping to reduce the offending and reduce the crime rate, and indeed the respect at which these sorts of courts have had from politicians from the right of the Republican Party to the left of the Democratic Party, the fact that the district attorneys buy into it, the police buy into it, and the judiciary themselves have bought into it. And it's quite extraordinary success, and that's why it's being expanded right across the states, and why I noticed even yesterday that the Justice Secretary, Michael Gove, in the House of Commons was talking about problem-solving justice models as something that should be introduced in the UK, and I very much think that in Northern Ireland we're small enough that we can pioneer this sort of stuff ourselves. I don't know if Alban wants to make any comment on it, but
yes, Chair. I think it was a very, very useful trip to see at first hand what was going on, and the whole concept of problem-solving courts is a novel one, certainly to us here, and I think to our colleagues in the South and in other parts of the UK. And I think that there is a degree of success there which is quite marked, which of course we rely on their figures, but nonetheless they're verifiable. The degree of recidivism is much, much lower, which is really what one's trying to achieve. And there's greater confidence in the administration of justice by local communities. It helps the morale of local communities, helps to transform those communities, gives them confidence not just in the courts but also the police as well, who sometimes are seen as sort of enemies to the community. So I must say it was very, very impressive, and we visited very tough areas. These were not by any means soft areas in terms of social problems, and the murder rate in some of the areas was quite significant. Although we were unmolested and we escaped unharmed, as other colleagues would be pleased to know.
Caught in the snow.
We escaped the snow as well, Chairman. But it really was worthwhile, and if we're going to do anything, if we're going to try and influence the courts, influence the Department of Justice, the police and so on here, then we've got to explore alternatives, and clearly these are viable alternatives, and we will do it differently, but they're aligning the courts, the social services and with the health service, and that's the key to success. And the other interesting thing is that once people go through the sort of mandate or processes that they have to go through, that there is the real possibility of a dismissal of the criminal charges against them. And I think that's a great incentive to people. They don't have this mark on their record. So I think it was very, very worthwhile.
We're going to pick up with, we've had a year of sort of looking at different approaches and innovative approaches in justice. So what we're going to do is we're going to have a small report and then bring it to the floor of the House, just an opportunity to discuss some of these issues and hear back from the department in terms of if they're minded to move forward within this sort of stuff. I did meet with the Bar Council earlier today, and they certainly are very keen on this type of thing and recognise the need for it as well. And I think some members of the judiciary do as well. So I think there is a will out there to look at this sort of model, and I'm bought into. Members of the committee probably know that, but I certainly think that there's stuff here that we should be doing here. So, okay, thank you. Then agenda item 4 is the Jenny second report on the monitoring of the implementation of the Youth Justice Review. Members will find the relevant information in pages 25 to 129 of the paper. So, if I can bring forward those who are coming to give evidence: James Corrigan, Deputy Chief Inspector; Rachel Lindsay, the Inspector; and David McAnulty, Inspector. And we're going to Hansard the session as well, and that will appear on the committee web page in due course. So I think, James, you're going to outline the findings of the second report, and then if there's any questions, we'll open up the members afterwards. So whenever you're ready.
Right. Thank you, Chairman, for this invitation to present our findings of our report. I'd just like to give a brief sort of briefing, an overview of the findings. In terms of background, after the devolution of justice to the Northern Ireland Assembly, there were a number of areas identified in terms of priorities and also for reviews. And one of those was the review of the youth justice system. So that was launched in 2010 by the Minister of Justice. Yeah. And the report was published in September 2011. There was two primary objectives in that report. One was to reduce the number of children entering the criminal justice system, and the second was to deal more appropriately and effectively with those who are part of the youth justice system. Most of the recommendations were accepted by the Minister, and a target of 90% achievement was agreed as part of an implementation plan. That was a joint implementation plan that was developed after the report was published. Now, as part of the delivery of those recommendations, the Minister requested Criminal Justice Inspection to assess progress against the recommendations and to prepare two reports. The first CGI report was published in 2013, and we found that there was significant work and significant activity by the Department of Justice and other criminal justice partners in delivering the recommendations. The second report, which we published last December, is the purpose of this particular event, and it's the last of the reports that was commissioned by the Minister. In terms of findings, the overall finding is that 59% of recommendations were deemed to be achieved by 2015. That's 26.5 of the 45 recommendations or sub-recommendations. Because, as you know, some of the recommendations actually had 2 or 3 parts to them in terms of specific issues to deal with. So we split those into sub-recommendations. The main finding in this final report is that there has been a drop or a difficulty in terms of maintaining momentum in implementation. And actually, we observed that from early 2014. And how that was manifested. Well, first of all, there was no update on the recommendations or on the progress against the recommendations by the Department of Justice since January 2014. We also identified that key supporting roles and structures were withdrawn. For example, the Department of Justice Youth Policy Team was dissolved. Also, the Criminal Justice Officer within the DHS-SPS, the funding was actually stopped for that particular role. And we also noticed that the Youth Justice Review was no longer an agenda item for the Criminal Justice Board. So I think these were all sort of indicators, pretty strong indicators, of a drop in momentum in terms of delivering the recommendations. However, and we note this in the report, there were some significant progress and successes over the period of the review, basically since 2010. And probably some of the most important successes was that very few people under 14 are actually in the Juvenile Justice Centre. That's an important development in itself. We also found that no children under 18 was committed to adult custody over the 4 years. There was no children under 18 in the Young Offender Centre in the 4 years since we did before the report. You'll also be very aware that youth engagement clinics have been operational recently, and they're showing a degree of success in diverting young people out of the criminal justice system and also being able to deal with offending behaviour at an earlier stage in people's lives. So that's important. It's important that low-level offending is being dealt with before the young children actually enter the criminal justice system. And linked to that, I think one of the very big successes for government as a whole has been the emphasis on early intervention. Because everybody recognises that at-risk children can be identified at a much earlier stage than when they enter the justice system. So the executive and essentially a lot of the government departments within the executive have made early intervention a priority, and a significant funding has gone into early intervention. So that's a very positive development, and it's in line with the spirit of the recommendations and the original Youth Justice Review report. But there are challenges, and those challenges we've found them in the report in terms of lack of progress against some of the recommendations. But there are also new challenges emerging since the report was produced, and certainly one of the key findings is that we found that the experiences of young people who come into contact with the criminal justice system must be improved. And we also found that looked after children in care are more adversely impacted by the criminal justice system than children who are not in care. We also found that the Juvenile Justice Centre is still used as a place for bail remand detentions. And that's very much against the spirit of the original report. And if you look at where the individuals, the children are coming from, it tends to be in the locations close to the Juvenile Justice Centre. So an example in Greater Belfast area, North Down. So that's essentially a differences in approach by the police, depending on where the young people are located in Northern Ireland. And I think linked to that, I think we have to recognise that the lack of progress on the Bail Act has created some more difficulties in that regard. And essentially the other challenge has been the lack of consensus around some of the key recommendations, particularly those around the need for legislation. Because if you look at the lack of progress on the Bail Act, the lack of consensus around the statutory age of criminal responsibility, the limited progress in agreeing or establishing statutory time limits to deal with the perennial problem of avoidable delay within the justice system, because we know that the children are actually much more disadvantaged in the justice system than adults when it comes to the length of time it takes to deal with their cases. And we also know that young people, long delays can be much more detrimental for young people than they are for adults, because 6 months or a year is a long time in a young person's life. And I suppose the last sort of issue around lack of consensus has been around dealing with criminal records of young people, and whether there's some scope for an initiative around, I suppose, cleaning the slate initiative, that type of. So I suppose in terms of looking to the future, I think we all recognise, even since the report was published in 2011, the original Youth Justice Review, the landscape has changed quite dramatically. And it's been new initiatives. The youth engagement clinics has been a new initiative since 2011. But really the big challenge at the moment is budgets. We do not have the same resources within the criminal justice system or the youth justice system that we had 4 or 5 years ago. So we have to find a way to do as well or do better with less resources. And that's a big challenge going forward. And I think the scoping study that the Minister announced last year is certainly an opportunity to tackle some of those challenges and help to establish the priorities for the next Assembly term. And we certainly feel that the issues that form the core of this report are issues which in many cases are broader than just the youth justice system. They need the input of other parts of government, whether that's education or health services or social services. So really this is a challenge for government as a whole, a cross-departmental approach. So thank you very much. We're happy to take questions.
Okay, thank you very much. Just a couple of things before I open it up to other members. In the briefing paper, you indicated that some of the recommendations within the Youth Justice Review were unrealistic and expecting both the spirit and letter of what was intended. Which recommendations are we talking about when you said that?
Well, there were a number of recommendations. I suppose we refer back to the legislative input particularly. To expect a change, for example, the change of the minimum age of criminal responsibility. It's a wide subject that there's a lot of public division on it, let alone the executive division or government division. So areas like that, you know, in spirit, they were probably well intentioned, and it would be keeping in, for example, in keeping with the Republic of Ireland and Scotland, where the age has been raised to 12, or across Europe, where the age has been increased to even greater ages. So maybe whenever the Youth Justice Review was first commissioned, and maybe that wasn't fully considered what the sort of other issues outside of the normal, what is the best interest of the child, could be considered. So it would be more of the larger issues that were probably unachievable at the time of the creation of the Youth Justice Review.
A couple of weeks ago, we had evidence from Include Youth and the Children's Law Centre, and they had expressed concerns about the alignment of the Youth Justice Agency and youth justice generally within the prison service, and now the Director General of the Prison Service is the head of reducing reoffending. I suppose it cements that link. Do you think it's appropriate for youth justice to be in that setting, or would it be better to be somewhere removed and standing alone?
I think there are, certainly us as inspectors, we've had different perspectives on this issue. Where does youth justice best fit? And really from our perspective, it's really where can the best interests of the child be achieved? And that could be within the current arrangements, within the criminal justice system, but perhaps, and we can certainly see merit in possibly youth justice maybe being in more associated with education or with the health services. It depends. It's ultimately the ultimate judge is where the rights of the child and the best interests of the child can best be achieved. And I think our point of view is we're not overly concerned around the actual structure. It's about how you're going to deliver those interests and those best interests of the child.
But are you seeing anywhere where, because they're, youth justice is aligned to almost an adult criminal justice system, is that holding back the delivery of any of the recommendations, or is it not something you're particularly concerned about?
I don't think it's held back some of the key recommendations that haven't been achieved, because I think some of the, as we've mentioned earlier, some of the major areas for more effort is around legislation, and I think that's about building consensus.
Yeah.
And I think some of the key improvements that we've talked about in terms of keeping young people out of the justice system has been achieved within the current arrangements. Yeah. I think longer term, I think it's a perfectly legitimate question. Particularly around, if this increased focus on early intervention and increased focus around rehabilitation of those that enter the system. But then perhaps there's certainly merit in much closer alignment with health and education and social services. Now, whether that means transfer into those departments, well, we're relatively open in terms of that particular judgment.
Okay, thank you. Alban?
Thank you very much, Chair, and thank you for your report and your introduction today. I'm very interested in the youth engagement clinics. I think they're a great idea, and you seem to give them a good, clean bill of health. Maybe you could reflect on them a little bit in terms of the the value of the diversionary effect that they have. But there's one issue which Include Youth and the Children's Law Centre raised, and that was the lack of legal representation in the youth or in the youth engagement clinics. The reason was that even if you undergo a diversionary measure, it can still count against you in terms of the criminal record. Now, if you have a solicitor advising you, it may well be in certain circumstances that you're admitting to an offence that, in actual fact or in legal terms, you didn't commit. And so it does create a negative impact for that young person in later life. So perhaps you could deal with that as well, if you don't mind.
I'll ask David to deal with the final part of your question first.
Well, certainly, as you know, this was a two-stage report. We commented on that very issue in the first report and the second report, that we had there was concerns raised to us that the whole idea is to take young people out of the system, as it were, and provide them with the best opportunities for their future and provide everything that's required to make them active members of the community. Now as a process that seemed to be quite well, it seemed to work quite well in youth engagement clinics, but there's been, you probably would have heard previously, that the uptake for legal advice was limited.
Yes.
Now, whenever we were doing this, we had raised these concerns with the interested parties, and we were assured that every effort was being made, particularly after following our comments from the first one, that we were concerned about legal advice, and that leaflets were being handed out. Young people were given every opportunity to get advice if there's any concern, whether there was issues of, say, defence being raised. It was being referred to the relevant bodies and relevant parties. Looking forward, it is difficult, and we acknowledge that it's a difficult area, because on the one hand you're trying to remove these young people from the legal system, and yet it's been held against them come age 18, because one of the other recommendations on the criminal records and the Snooden-Mason review and the case of MM in UK suggest there should be a cleaning of the slate, and we would commend the Lord Chief Justice's comments about expunging records on that footing. So it does create an issue that maybe the two things are maybe slightly out of kilter, but as we found it at the time of the inspection, efforts were being made to provide as much legal advice as possible. Now, there may be a number of reasons for that. We didn't go beyond that as to investigate with the Law Society. Are these young people not being made for services? Is there legal aid in place? There is legal aid in place for advice and assistance. There might be a number of reasons for that. But certainly we did acknowledge that there was potentially a disparity.
Yes, and I think you put your finger on it, that unless we tackle the situation where people carry forward criminal convictions or diversionary measure as a criminal conviction effectively, unless we tackle that, then we're still going to have this problem of whether or not there's sufficient legal advice at first instance. So, but it is reassuring that in fact efforts are being made, and you think that those efforts are genuine and sustained in relation to legal advice being given to young people. Yes,
the only concern we raised in the report was that sometimes whenever they're being advised by, say, the authorities that are carrying out the clinic itself. So a young person, a youth advisor within the police service, as it were, was given the same advice as to what will happen if they take this. And so that initial advice, maybe that could be improved, or the initial advice with a solicitor, as you've suggested. Yes. There might have been an area for improvement there, and the figures don't look good for the uptake of solicitors at the clinic stage. Yes. So there is room for improvement there. We do acknowledge that, and we can't let that lie, as it were. I mean, that's something that should be followed up on.
And in a more general sense, in terms of the youth engagement clinics, we are supportive of the principle behind the clinics, in the sense that it's trying to deal with offending behaviour at a much earlier stage in a system which has been very, very slow up to date and actually hasn't really been very successful in terms of dealing with young people. It's also been a more effective way to bring the different partners together to deal with the needs of the young person at an early stage. And I suppose it's also possibly one of the reasons why the number of young people in the justice system is actually falling. Because it's very noticeable in recent years, there's less young people, less children entering the justice system and less children held in custody. Now, whether that can be directly correlated to the youth engagement clinics, we're not absolutely certain at this stage because it's still a relatively early stage of development. But on balance, it appears to be a positive development with the right type of principles.
Thank you very much, Chair.
Okay, Raymond.
Excuse me. Thank you very much, Chair, and thank you very much for your presentation. Just in relation to in your briefing document under assessment of recommendations, at the first inspection report you found that there was an implementation plan. By the time the second report, was that absent by that stage?
Well, it was absent in terms, the plan was still in place, the implementation plan, but it hadn't been updated since, I think, January 2014. So there was essentially the people that were responsible for implementing the plan and coordinating the input from all the other partners. Essentially, that had stopped. And as I mentioned earlier, some of the key roles and the liaison points had actually, the funding had stopped for those as well. So essentially, it was a kind of an impression that it would seem to be less of a priority in 2014 and 2015 than it was in 2012 and 2013, and that, you know, the lack of progress against some of the key recommendations was disappointing that lack of momentum had happened, even though there was still quite a lot of activity still required to deliver the recommendations.
And in terms when you were carrying out the inspection, was that rationale provided to you, or was that just something you sort of ascertained?
But certainly, whenever we went back the second time, there were first out there was a number of meetings that used to be held, regular stakeholder meetings, and that was headed by the Department of Justice, and that was an update on how things were progressing, and it was a chance to bring all the interested bodies and stakeholders together and say, well, this is what's happening, this is the progress. Now that had stopped. The implementation plan itself, there'd been no updates since January 2014, and what that meant was that we had to go to the different agencies and say, well, what is it that's currently positioned and what has changed since the last occasion. So I think on that basis we felt that there had been some momentum lost, but we've added that into the youth policy team within the Department of Justice. It had been disbanded, for want of a better word. It no longer was in existence, and if you add those things up along with the reduced resources, I think that this potentially could have been a reason for the lack of momentum, since we found in the first one there was lots of activities, lots of meetings and lots of progress updates. From January 2014, the only updates they got were the ones we got ourselves.
Was it clear, or was it apparent that say like the stakeholder meetings was stopped, that there was a decision to do that, or is it just they just
again, because the youth policy justice team, people had left, retired, and people had moved on to different areas, different sections. The first we really knew about it was whenever there was no meeting in the following quarter, as it were.
But I mean, obviously, and the officials will be here, and I'm sure they'll provide an explanation why the youth policy team left. But the function of the implementation plan and the stakeholders meeting should have been, one assumes, taken up by someone else. Would you agree?
Well, it certainly would have made our job a lot easier. Whenever we didn't inspect the second time, we would expect that this is fully updated, and we then go and verify.
But in terms of recommendations not being implemented, then that would have been their key role, to ensure that the recommendations were being
certainly,
followed.
it's the assimilation and gathering of evidence into one place, which made it easier to comprehend or to use for us. But as was already mentioned, there's a wide range of agencies and bodies involved and departments, which it is a complicated process.
Yeah, I mean, and I know this perhaps isn't a question which you need the answer, but was there a sense that perhaps the department felt that they'd taken the recommendations as far as they could, and all these things were now unnecessary?
I don't know what the department will say on that, obviously. As much as we can say is that we felt that there was a loss of momentum. I think that's as far as we could say it. We don't know the reasons for it.
Yeah, and in terms of, I mean, I know in terms of some of the recommendations you said there would have been a lack of consensus, which, I mean, I think it's fair enough to say, but in terms of, say, like the Bail Act, the age of criminal responsibility and statutory time limits, is the lack of consensus enough, if you like, of a validation for the recommendations not to have been progressed? Or do you think that the department should have at least made a better attempt to resolve some of these issues?
Sorry, go on. Go on, Dave. I think it depends. There's different issues for different pieces of legislation. So, for example, the Bail Act, there has been a consultation process on that, but I think the issue with that is that other pieces of legislation have taken priority, whereas in other aspects, so for example, the minimum age of criminal responsibility, that has been stalled by the lack of consensus. So it depends on the piece of legislation as to what the particular issue is.
Yeah, but in terms of the Bail Act, so would the department have said that they didn't see that as a priority or lower down in their priority list?
Yeah, yeah.
Okay. And in terms of statutory time limits, because I mean, we've had a number of presentations around statutory time limits, and it would be fair to say perhaps there wasn't consensus, but at least there was progress. So would you have any view on that?
I think the problem with the statutory time limits is the recommendation was quite clear. They set a statutory time limit of 120 days, but there was an end-to-end time limit from arrest to sentence. And essentially what the department was proposing was a time limit on the basis of legislation from 2003, which was not end-to-end. It was much later stage in the process. I think that was kind of missing the point of the statutory time limit and the spirit of the statutory time limit, which was that it needed to be to cover the maximum period of somebody being within the criminal justice system. So I think the department and others have recognised that fact now and have said, well, actually, we need to start again. Yeah. But it's unfortunate that it's taken so long. And of course, statutory time limits. Criminal Justice Inspection was recommending statutory time limits 10 years ago. Now we were very specific in 2010, 2011 that the statutory time limits should start within the youth justice system, because that was where the biggest problems of delay were actually occurring. But also we recognised that it was good practice to essentially trial the statutory time limits in the youth courts before it be extended to the other parts of the justice system. Now, we also recognised that there was different viewpoints from different political parties in terms of some of the difficulties around statutory time limits, but all that could be worked out as part of forming the legislation. So I think, certainly from our perspective, statutory time limits are still an important plank in terms of reducing delay. And if it doesn't, it's not going to happen in this term, but it should certainly be a priority for the next Assembly term.
And final question, and perhaps more of an observation. You say in the briefing document, part of it, that there was a lack of strategic oversight from the department, and that the implementation of the recommendations was no longer a feature of the Criminal Justice Board agenda. Were you provided a rationale as to why that was the case?
No, again, it's more or less the same questions before the same answers. I should say that it was an observation we made from a chain of events, or a lack of information, or a lack of updates, and lack of resources and changes in the team. I don't even think that there was a point of contact, because different department bodies had moved into different departments, as it were, so there's not really a focal point for us to go to within the department. Was the key issue. Okay,
so I mean,
and again, to answer the strategic, was there no strategic oversight? Again, that area had moved in. There was a question asked earlier, the reoffending division, and again, that was happening during the process whenever we were inspecting, and we weren't able to comment on that because it was post-inspection, as it were.
This is a final question. Would you have expected that there should have been more oversight, and that perhaps that they should have remained a feature of the board agenda?
Well, certainly it was our view as somebody who was monitoring the progress of the recommendations that it would have been very beneficial for it to have a higher priority within the justice system. And I think the very fact, if you want to look at the top priorities within the justice system, I think you get a good indication from the agenda of the Criminal Justice Board and the priorities of the different organisations. And I think when some issues start dropping off those agendas, I think it gives you an indication of they've been replaced by new priorities. Now that's the feature. There's always going to be, like prisons, for example, is a big priority at the moment. Events change, circumstances change, new issues become big issues. But we feel that the Criminal Justice Review was unfinished business. There was still key changes required and key progress required. And I think it was just a bit maybe premature to make those changes at that stage.
Okay, thank you.
Okay, Sammy.
Thank you, Chair, and thank you for your presentation so far. I'm sure you'll agree with this quote from Kofi Annan, and he said, "Knowledge is power, information is liberating, education is the premise of progress in every society and every family." The Children's Law Centre and Include Youth had briefed us, and one of the things that they were saying was that obviously the Minister of Justice has recently highlighted that in 2015 significant numbers of staff left the YGA under the Civil Service Voluntary Exit Scheme. With the JJC staffing levels within the Education Learning Centre have also fallen considerably, resulting in the number of hours of education delivered to children falling. That's a big concern that we would have as a committee. Could you tell us what you're actually doing to address these serious issues?
Yeah, I mean, we would carry out inspections of the Juvenile Justice Centre on a regular basis under our responsibilities. As part of the UK's national preventative mechanism, we have to inspect places of detention here regularly. So we would sort of roughly go in on a 2 to 3 year cycle. So that is something that, I mean, our last inspection of the JJC and this piece of work was obviously before that, the numbers of staff has reduced. So therefore, that's something that we will obviously be keen to inspect when we next go back to look at it.
And given the current situation, in terms of education provision transferring to the Education Authority, can you give us an assurance that provision will be available for the appropriate resources to ensure that all those children get a decent education?
Well, I mean, again, that will be something we'll be looking at when we go back to inspect, and we've always been of the view that education is a key provision for young people in the Juvenile Justice Centre, and our inspections are done jointly with the Education and Training Inspectorate. So, again, when we come back to inspect the JJC, that will be something they particularly will be focusing on.
Thank you. Thank you, Chair.
Okay, thanks. No other members have indicated, so thank you very much. Appreciate your time.
Thank you.
Okay, members, we'll move on to agenda item 5 then, which is a briefing from officials of at DOJ. Pages 131 to 134 of your packs. If you want to invite the officials forward. So we're welcoming Declan McKeown, Chief Executive of Justice Agency, Gary Ockey, the Director of Justice Services, Paul McStravick, and Ciara Lloyd. And something similar then, so if there's any introductory remarks, we'll take those and then open up the members afterwards. So Declan, I think you're opening up, is that right? Okay, then whenever you're ready.
Okay, well, thank you, Chair, for the opportunity to discuss with the committee the latest CJINI report on the implementation of the Youth Justice Review recommendations. As the committee has already been briefed by CJINI staff, I'll not rehearse the background to their report, which, as you know, is the second and final progress report and implementation. Rather, I will jump straight to the report's headline figure, which stated that 59% of agreed recommendations have been implemented against a programme for government target of 90%. I want to acknowledge up front that this figure is a source of great disappointment for us. I think it's worth saying at this point that in making our previous internal assessments of progress and reporting against the programme for government target, we had taken a slightly different view on how progress in some areas was measured. In effect, we assessed the progress made on the procedural, legislative and structural changes which were required for an improved youth justice system as envisaged by the review team. In its assessment, however, CJINI was much more focused on achieving and evidencing positive outcomes from those changes. Taking this view of progress, we therefore accept CJINI's independent assessment and concede that, while significant progress was made in implementing many of the recommendations, particularly those within our Minister's gift to deliver, we did not achieve the target we set for ourselves, and that there is still much work to be done. In that respect, we are in full agreement with the inspectors on the ultimate importance of achieving the right outcomes for children coming into contact with the youth justice system. As outlined in our briefing paper prepared for the committee, there are a number of reasons why we believe that full implementation of some of the recommendations was not completed. The biggest challenge we faced was the fact that the breadth and scope of the review meant that many of the recommendations were out with the direct remit of the Minister of Justice. I understand that throughout the process the committee had expressed concern about our ability to deliver on these, given our lack of direct responsibility, but we were content at that time that there existed sufficient goodwill and cooperation to succeed. Unfortunately, what we did not envisage were the financial and structural constraints that have been a feature in recent years and which have led to shifting priorities, meaning that it has sometimes been difficult to maintain focus and momentum on delivering the recommendations, particularly where we had no direct influence. The report does indeed acknowledge this challenging operational environment within which implementation was being delivered and recognises the important successes that have been achieved. It also understands that for particular recommendations, namely those relating to an increase in minimum age of criminal responsibility, implementation was entirely out of our hands, given the lack of political support. Whilst disappointment amongst committee members regarding CJINI's assessment is completely understandable, there is nevertheless a positive tale to tell in relation to the progress made in improving our youth justice system. The report cites a number of achievements across a range of responsibilities and at every stage of the criminal justice process, and we would be happy to discuss that progress this afternoon should members want more detail. We are, however, very aware that more work is needed in other areas where progress has been slow or has not delivered the outcomes we had wished for, and we would like to place on record that this work does not end simply because the final CJINI report has been published. Indeed, on the 21st of May 2015, you may recall that officials attended a meeting of the Justice Committee to brief members on the comprehensive scope and study on children in the justice system that had just been announced by the Minister. This scope and study is a continuation of the work begun by the Youth Justice Review and builds on some of the procedural and structural changes made through the implementation of the review's recommendations. The entire exercise is being undertaken with a view to improving outcomes for children by, in particular, keeping as many as possible out of the criminal justice system and providing effective, targeted support and intervention. The work links directly to a number of the recommendations and, crucially, the underpinning principles in the Youth Justice Review. For example, the review made a number of recommendations around early stage intervention and prevention. Therefore, one of the scope and study subgroups is examining options for maximising non-criminal sanctions and providing support and services to children and their families at an early stage to prevent them entering the formal justice system, thereby avoiding the negative life outcomes that often follow as a result. Part of this work will also consider how we can deal with this type of low-level offending without the consequence of a criminal record, while still ensuring that children are held accountable for their actions. The review team also proposed a range of improvements aimed at reducing the number of children admitted to custody, either on PACE or remand, and the provision of alternative accommodation to assist with this. This was an area of work where, unfortunately, we failed to make a substantive impact due to the complex and interrelated nature of the underlying issues and the lack of alternatives available to us at that time. We are acutely aware of these problems, and we therefore have a subgroup focused on these issues and are developing proposals for a range of alternative approaches, some of which may require legislative change, with a view to custody for children truly becoming a last resort. The scope and study will also deliver on the Minister's commitment to underpin the removal of children from Highbank Wood in legislation, which again was a key recommendation of the review team. The current work we are doing will be particularly important in delivering some of the more complex recommendations in the review, which require step change in thinking, along with significant support across a number of executive departments before implementation could be possible. I should say at this point that throughout the exercise so far, the engagement we have received from representatives of key departments and their agencies at both steering group and subgroup level demonstrates a joint commitment to the work, which makes significant change possible.
We are therefore confident that any proposals made as a result of the scoping study will have the backing of those involved in implementing the changes. Overall, this work is progressing well, and we hope to provide the Minister with options for consideration, which he can present to the Assembly prior to the new mandate. The Committee will, of course, be kept appraised of progress. In closing, I hope this gives members an overview of the progress that has been achieved to date and the work which is ongoing, our continued efforts to develop the youth justice system and improve outcomes for those children within it. We're happy to answer any questions you may have. Thank you.
Okay, Declan, thanks very much. We'll pick up on a few issues that were outlined in the report. First of all, the report outlined that by April 2015, the Youth Justice Review was no longer a standing item at board meetings. Why was that?
The sense that we as a department had was that we'd very much progressed against many of the targets, and therefore it no longer was seen as a key priority piece of work to report on day and daily, because we felt that we had achieved many of the targets. Now, as I've said in my open remarks, we've since realised that that isn't the case. What I would say is that the scoping study has been very much central to the work of the Criminal Justice Board and in Justice 2020, when we're developing our objectives for the years ahead and into the next mandate. So I do think we have still kept children and the needs of children front and centre of what we're doing as a department, albeit that it's now more tagged under the heading of the scoping study.
And the DOJ Youth Policy Team was no longer in existence, so again, why was that?
I guess some of that's in a name, because what we have is the Reducing Offending Policy Unit, which is headed up by Ciara. And what I did very early on into taking over the role was to augment that team with our Business Improvement Directorate, because I felt that Ciara and her team were providing us both with reducing offending policy advice and youth policy advice, and that we had experts within our team. So the sense for me was that we would build greater synergies by putting them together. So while it's true to say the youth policy team per se doesn't exist, the Reducing Offending Policy Unit has been augmented to take on board all of the youth issues, and we have a bigger, stronger team for that.
Okay, and the role of a criminal justice officer in the Department of Health was ended. Again, why was that?
I think there were many issues to look at, and one of those will have been the financial perspective that we had at that time. And as you will know, at that time we had faced 12% cut to our budget. We had to look at how we made sure we still maintained that role of providing a monitoring role down in the centre, but also make sure that we could cut our cloth appropriately. And what we did do was, yes, it is true that that role was no longer there, but we replaced that role with an independent board member who carried out that function on the agency's behalf. He still provides those detailed reports, and indeed those reports, as I'm sure Paul will agree, set the agenda for the work of this JJC. So we still have that monitoring function. It's still carried out independently, and it's still very thorough, and a report is produced each month, which is considered at the agency board as well.
And tell me a bit more about that role. What exactly are they doing? Are they coordinating between the two departments, or what exactly does that look like?
Well, I'll pass that to Paul, but it is very much the same role that was being carried out in the past, but maybe Paul wants to elaborate.
Obviously, we have monthly inspection reports handed to us. Obviously, we have action plans from those as well. The independent person, board member, comes in, talks to the young people, talks to all the staff on duties, staff raise various issues with the independent board member. That's reflected back to the board meetings as well.
Both yourselves and previously we heard about this loss of momentum. So how do we get that momentum back, and who's charged with trying to get that back on track?
I think the momentum is back on track now, and I do think that the scoping study has given renewed momentum to it, because a lot of what, in fact, all of what is in the Youth Justice Review will be covered by what we're covering in the scoping study. And I think the renewed vigour that's got behind it, and maybe driven by the fact that there's a smaller budget around for all departments, I think people are coming to the table now across the various agencies and departments with a can-do approach. And certainly that's been borne out over the last 8 months when we had the steering group and the subsequent subgroups, where we've had departments and agencies represented who are coming to it with a fresh approach. And certainly my personal view, and to answer your question, who's charged with making sure it happens, probably me then, as the head of the steering group. I think that the momentum that's starting to build, and the good ideas that are starting to take shape coming out of this, both the subgroups and the steering group, will continue that momentum. And I do think a lot of the issues that have been outlined by James and his team earlier this afternoon will be referenced, and there will be proposals to take them forward. So I think that's where the momentum will come from.
I think also it's important to say that the scoping study is actually a continuation of the work of the Youth Justice Review. So it is, in essence, the recommendations that Sajini were showing us that we weren't as fully developed as we want them to be. We had been looking at them from the putting in place procedures, putting in place processes. So Jenny, quite rightly, we're looking at whether the outcome that had been sought by the review team had been met. The scoping study was a way of scooping up all of that, focus on the outcomes, considering where we felt that we hadn't actually gone back enough to what the original outcome of the Youth Justice Review was, and actually driving forward those looking again at outcomes. So considering issues such as PACE, for example, and the use of PACE, considering whether Woodlands is indeed the most appropriate place of safety in Northern Ireland for children. Those are the kind of issues that were raised by the Youth Justice Review. We had started to put in place processes and procedures in our implementation plan, accepted the fact that that didn't necessarily go far enough. It was a very necessary step, but that more needed to be done, and therefore the scoping study is actually very much a continuation of the work that was begun by the Youth Justice Review.
In your written briefing, you say about how the scoping study has engaged with the key organisations and departments, and fully engaged, I think was the term that was used. That's not what we heard from the Children's Law Centre and Include Youth, who said that engagement was very limited. I just wondered whether you would accept that or whether you take a different view.
Everyone will have their own opinion on it. I mean, certainly my sense, and certainly and remains to be seen if that is the case, but we have taken very much an outreach and approach. We did meet with the voluntary community sector very early on, I think it was around September time, to outline our thinking to date. I also chair the subgroup of the Children and Young People Strategic Partnership on Reducing Offending, where all of those groups sit around the table, and I outline in detail about, I give them a presentation at our last meeting about what we were planning, what were the types of proposals that were starting to come forward, etc. My sense then, to answer your question, is that we have engaged them. Bear in mind it's an 8-month window, and as well as we can do, but I take the point that some may feel that they're not engaged enough.
I think when it comes especially to the other government departments, we have seen a massive shift in, for example, education and our relationship with education and the responsibility that they are taking for the education of children in Woodlands. Massive shift. Also a large working development in the working relationship with the Department of Health, with the trusts, with the trust in which Woodlands is based. Significant progress in terms of areas of responsibility and a commitment by all departments to work a lot closer together. One of the issues that we've had, and we've had been very clearly highlighted by the Youth Justice Team and others, is that the needs of the child are holistic. The child comes with many problems, but it is one child. And as a government executive, the way that we split departments does mean that we each address a different part of the child. So if you have a child who is offended, we address offending, but they're also very likely to come from with mental health problems, which is addressed by somebody completely different. They're likely to have fallen out of school. That's addressed by a completely different department. Yeah. So you have 5 or 6 departments all addressing the one child, but all looking in segregated ways, in siloed ways, at a specific part of that child's needs. And the only way we ever get that better is by coming closer together, by looking at structures, by looking at the procedures and the processes, and who takes responsibility at what point for the child. And that's a lot of the things that we're exploring as part of the scoping study. And again, it's been raised many times over the years. It was in the Youth Justice Review, it's been raised previously by voluntary sectors and other people, and we are considering it, and we're looking at it, and we are working very closely with our colleagues in other departments to see where we can breach those gaps.
I mean, I think that's key. I mean, even not just with young people, but with adults as well. I mean, myself and Alvin were talking earlier on about the whole problem-solving model of justice, and the more you look into that, the more you see how many people here in the criminal justice system have mental health issues, have addiction issues, have had difficult upbringings, have a lack of education. So it is absolutely important that both health and education play their part in trying to avoid people coming in contact with the criminal justice system in the first place, but in helping to solve the problems of why people keep offending. Just finally, in terms of where youth justice sits within the overarching thing, I said in previous months about if we wanted to be really radical, it could go to education or sit somewhere else. The fact that it sits under the Director General of the Prison Service, I mean, I do think that perception-wise doesn't fit particularly well. I just wondered whether you had any response to that and whether it's something that you'd look at again.
I think what I would say is wherever the Youth Justice Agency is best placed, I mean, that will ultimately be a political decision, and I understand that, and I can see the arguments for it being in health or education. If I take it from my own personal view, and having been in post coming 18 months now, being part of the Reducing Offending Directorate and working under the Reducing Offending Director, and I appreciate that the Director General wears both hats, I found it to the ultimate benefit of the agency because we were able to share resources, we were able to look at synergies, as I've outlined earlier, how we've been able to work closer with Kira's team, but also to look at things such as the Reducing Offending Strategic Framework and the Desistance Strategy. All of those avenues to have those discussions at a strategic level exist because we're part of the Reducing Offending Directorate. So it may well be down the line that people decide that it would be better placed in education and health, and I don't mind that at all. But for the moment, it is working very effectively, and I understand people's perceptions, and I know the comments that we're under prisons. We're not. We're aligned alongside prisons under Reducing Offending, and Reducing Offending is the brand that we work towards. And certainly I know at my level, working with my colleagues, that I've had their support for the 18 months I've been in post, and I know as the levels as we go down, we've had a sharing of resources and ideas. So it works very effectively for me, and I think that's borne out in the successes we've had in scope and study to date. Excuse me.
Okay. Alban?
Thank you very much, Chair. I think, Chair, you've asked all the questions that really need to be asked in relation to the report and the inspector's report and so forth. But what worries me is this loss of momentum, and I think I understand what you're saying is, yeah, there may well have been a loss of momentum, but we are now rebooting, as it were, the Youth Justice Review, and you put particular emphasis on the scoping study, that you have faith in this study, and that this will in fact energise the programme again. Is that fair comment?
It is. I would go as far as to say, not that it will, I think it has already.
Right.
I think, we really started on this process, if you think back to Minister's announcement, excuse me, in November 2014, where he set down the parameters of this work and then announced it formally in May. That wheel has been turning ever since, and I think that momentum has been building, which has made it easier in the 8 months since to start bringing people together and draw together ideas.
Well, the one thing that worries me, of course, is if there further cuts. I mean, you had a 12% cut. If there are further cuts this year, I don't know, I haven't looked at the thing in detail, but if there are further cuts this year, is the programme really sustainable in terms of achieving the success that you reasonably would regard as being attainable within the year?
I would say yes, and if I go back to shortly after taking up the post, we were faced with a 12% cut to our budget for 15-16, the year we're in now. I brought together the senior team and I also talked to staff, and what I said was that we would take a zero-based approach. We'd basically look at what needs to be done and we would build the budget accordingly. As it turned out, and I give this commitment to all staff, that they will not see any marked difference on the 31st of March of this year and last year, and the 1st of April, and that has been the case because we've kept at the centre of what we do the childcare ethos and the approach that we take to working with children. That remains. What we've done is we've looked cleverly at how we could manage our budget, and we've looked at ways in making savings, and that has been the driver for getting that 12%. This year, as we approach it, we're still looking at the budgets and we've still to get our final budget allocation. But my sense and the indications, and you're probably already aware, will be that it's much smaller. That gives us actually a bit more of a budget to start planning ahead along with the ideas in the scope study. So in short, I think we've managed well within a huge cut last year, and we've planned and cut our cloth accordingly. We've done a lot of workforce planning and prioritising for this incoming year, in the anticipation that our cut would be much higher. And I think, therefore, as we move into the 1st of April onwards, that we're in a good position.
Thank you very much, Chair.
Thanks, Clement.
Thank you very much, and thank you very much for your presentation. I just want to return to the scoping study and the implementation plan. I think from your your presentation today, you would accept that the Youth Justice Review dropping off the Criminal Justice Board agenda was premature.
I think it was because it was based on probably a misunderstanding insofar as we as a department would have thought we had progressed further than we had. So yes.
And in terms, would there be a clear recollection when that decision was made that we have progressed this enough? It's no longer necessary now for this to trouble the board with the justice review. We have taken it as far as what's necessary or as we can.
I think colleagues in Sejeni have outlined that it was probably in the spring of 2014, and that would have aligned very much with the time that both there was that understanding internally that we progressed well, but also a change in structures within the department. So while there would have been a decision around then probably that the focus would change slightly, it might have also been exacerbated by the fact that there was a change in the structures, and maybe there was a hiatus for a couple of months into the summer period. But certainly I can speak very much from October onwards of that year. The momentum coming towards the scoping study brought renewed vigour to it all, and we started moving forward on that basis. So in short, I think it is probably fair to say it happened around the springtime. It was probably on an understanding that we'd progressed far enough, and it was probably exacerbated by the fact that there was a restructuring within the department.
I think also it would be whenever you have an implementation plan and you have actions against an implementation plan, and your view is that in the main the implementation actions had actually been put in place in terms of the processes, in terms of the way that people were working, in terms of getting providers from the PSNI's perspective, some of the training they were doing. And there was a time then to allow it to bed in. So there comes a time when you're moving from implementation in terms of putting in place something and monitoring whether something has been put in place, and then it becoming part of day-to-day operation and bedding into the system, where you're not necessarily doing what you would call an implementation action plan anymore, but you've got their recommendations and the processes implemented, and what you're checking on then is whether they're having the impact that they should have got, which is where we come back to looking again at outcomes and considering the fact. So whilst we weren't monitoring necessarily continuing implementation, what we were then looking at was outcomes, and that leads you into where the scoping study kicks in.
Yeah, but see, I get the impression, I might be wrong, and I'm sure you'll correct me, but you see, you get the impression this dropped off the agenda rather than someone taking a very, if you like, strategic decision to say this is no longer necessary.
I don't think it dropped off would be a fair comment, but I understand what you're saying. I think what it was that there was an understanding, as I've said, that we'd progressed as far as we could at this time, and I think, and it's borne out in a letter to the Justice Committee last November, where we had said that we felt that we'd progressed far enough vis-a-vis the Youth Justice Review, but we recognise that there's still pillars of work to be taken forward, and that we will make sure that we don't lose sight of those. And as it has been, those pieces of work have moved into and under the banner of the scoping study.
But I mean, just to play it, who decided that there was a need for a scoping study, and why?
What was the Minister's decision, and it actually came...
when I asked why, he must have been... I don't think he just decided I'm going to have a scoping study. Somebody must have told him that there was a need for it.
Well, what had happened was, and members may recall this, that there was a lot of talk at the time about looking at how we develop legislation to keep children out of Hydebank. Yeah. The more we returned to that legislation to see how we could do it, the more complex it became. And the conscious decision really was... And coming from ourselves, but also the decision of the Minister, was very much that we could spend all our time and all our resources trying to fix the legislation to keep children out of Hydebank, or we could devote that energy to take a renewed look at the work that needs to be done for children from an end-to-end perspective. So that's why in the autumn of that year we moved and diverted our focus in that way.
Yeah. And is there now a very clear implementation plan how to resolve the rest of the recommendations?
What we've done is we've kept these at the forefront of our mind, all of the issues that are still left to take forward through the Youth Justice Review, and they've been central to the subgroups that have been set up to look at how we move forward. So what we're hoping in the latter part of the spring, and probably around about late February, early March, is that we will come to the Minister with a set of proposals, worked up proposals, on how we think we can move forward on the various issues, which will include a broad suite of issues that were contained within the Youth Justice Review and more.
But where I would say that there are some things we can't do. So, for example, one of the recommendations which was not achieved was the establishment of an early intervention unit within OFM DFM. That has been taken over by the Early Intervention Transformation Programme, which is having great success. So that doesn't make sense for us to continue on as an implementation of a recommendation, because it was a recommendation that was made in 2010 that no longer actually would stand, because we have absolutely no sway over that. Likewise, minimum major criminal responsibility would be another one where if we're taking it forward in the absence of a political consensus to actually implement it, there are things that we can do in order to encourage younger children out of the system. But legislatively, without political consensus, we can't actually implement that. So there are certain things in the Youth Justice Review recommendations that we're not going to be able to meet.
And in terms of the scoping study is now concluded, and there's clear
It's still being concluded. What we had given a commitment was that we would bring a set of proposals to the Minister in February of this year. We have the steering group that meets on the 8th of February. We hope following that, and we will come to the Justice Committee with our proposal.
And in terms, and the Chair alluded to the Youth Justice Policy Team and our posts, are you very, very much of a mind now that there's a very, if you like, clear oversight and monitoring mechanisms in place to take us forward?
Yes, and I say that because, as I say, we are developing within the department what's called Justice 2020, which is looking towards the next mandate, and we are part of that Justice 2020 document, and we've set out the key metrics that we will measure ourselves against over the next 5 years, and tied to that, we were developing indicators as well to measure our progress. So, short answer is yes.
Okay. And in terms of, and again, this was, you already touched on this, but the idea of the Director General being the chair of the Reducing Offending Division, we're satisfied that the focus will still remain child-centred?
I have, as I say, been in post nearly 18 months, and that role carried out by the Director is to provide that strategic oversight, but also gives me a great degree of autonomy to look at ideas. Yeah. So I think I get the best of both worlds from it.
So, but I suppose I'd ask the question, if you believed that there was if you like, a moving away from child-centred aspect of your work, you would be confident enough to say, look, this isn't working and we need to be somewhere else?
I would, and I would know that I'd be listened to.
Yeah, okay, that's good. And in relation to, and I know that was one of the 3 items which you would accept in relation to a consensus, but the Bail Act, would you accept at present that there is a gap in relation particularly to children in care, that's something which needs urgent addressing in relation to like both PACE and bail procedures?
I do, and as I say, it forms part of the scope study. I don't know if Ciara wants to say anything.
Yeah, one of the things, I mean, we're conscious that there were an awful lot of recommendations made by the Law Commission regarding bail for children. We absolutely agree with them that an awful lot of the issues that we have around children and some of the conditions that are set for children for bail conditions, and a lot of are unsuitable. And a lot of the work of the scoping study has actually been on how we can invigorate that area around bail, both in terms of police bail, in terms of oversight, in terms of putting in place gatekeepers, and also in terms of judicial bail conditions and how we can work with the judiciary on those. And those are all forming a part of the scoping study, so they're a key part of it and will be a key part of any legislative agenda in the next mandate.
Yeah. So like, I'm not saying you'll conclude everything in their next meeting, but you would have a clear indication within the next short while of where you're taking that in terms of the next mandate?
Yeah. And by the time we come back, I think it's the 3rd of March to the Justice Committee, we should have an outline of the type of proposals that will be coming forward.
And would it be similar with, I know the age of criminal responsibility, I think there was less consensus, but I think in fairness to the committee in terms of statutory time limits, you know, at the beginning there might have been a divergence of views, but I think the more we heard and the more presentations we got, I think there was at least an understanding of not just what it was about, but the impact it can have, particularly in reducing offending. So I'm just wondering, what's the timeline for that going forward?
Well, there's a consultation exercise that's ongoing on statutory timelines, which I'm sure committee members will know about. I'm not sure of when it's to report. It's not our director of responsibility, but it went out in December 2015. So I suspect towards the spring into the summer of this year.
Yeah. What they're currently looking at, they issued a consultation December 2013 on time limits in youth courts. So that's actually, statutory time limits is one of the areas which isn't actually being addressed in the scoping study, because there is a whole other area of the department who are looking at statutory time limits, and they are going out to consultation at the moment. So there's opportunities for members of the public to at the moment comment on how they view statutory time limits being taken forward, and that is reopening the conversation around amending the legislation in order to introduce a new starting point.
Okay, thank you. And I suppose my last question would be, or comment, maybe question is, the idea of it being on the board's agenda, do you think that's something which should be now a priority for to ensure this remains a feature at the board's agenda so as it's seen as a priority?
I think if the scope and study is seen as the umbrella that captures all of this work, and the fact that we are now figuring in Justice 2020, and we've been already asked, Ciara and I, in the summer of last year to do a presentation to the board, I think we are there already with that, and I think there is an interest each month on it.
Okay, and just in relation to the gap created by the policy team and the Justice Coordinator in the Health Department, do you feel that gap has now been closed, or is it need they move to close, or they?
I think since we put in place the new arrangement with the independent monitoring officer, I think it's worked very effectively, and certainly the reports that I get each month have really set the tone for the work. And Paul will know, and Brian, if he were here today, would say that on receipt of those reports, once I consider them, I usually send them straight to the director and to Paul and say, right, we need to take action on these particular points. So I think they've been very effective.
Yeah. And 12 months from now, or obviously whoever the next committee is, we'll be in a better place in relation to the recommendations from the Youth Justice Review? I
think we will, and I think we're already starting. I mean, if you look, and I'm sure some members will have comments on today about PACE figures, we're already seeing in the last 12 months a 9% decrease in the number of people being paced. We're seeing less people going through Woodlands. In fact, on remand and sentences, it's up around 20+%. So I think we're already starting to see that. Education, as we've spoken about earlier, we've made huge strides in that over the last few months. So, yes.
Okay. Thank you. Thank you very much.
I would just echo Raymond's comments about the STL as well. I mean, it's before my time that there was concerns around, I think, the idea that if a statutory time limit wasn't met, that the person who potentially would be in front of a court, that case would fall apart. I think once there was reassurances that wouldn't happen, the committee's view was actually, are these time limits challenging enough in the first instance, and secondly, to make sure that extensions to STLs wouldn't become routine. I think that's where the committee's concern was, rather than being opposed to them. So I think you're maybe being a little bit economical with the realities of these things, and the department keeps changing their mind on it rather than anything else. On the age of criminal responsibility, I mean, you're right, there's not political consensus on these things. I think that the Jamie Bulger case has made it very difficult for any politician to want to move away from the current age. I think we need to have the capability to bring prosecutions, but there are many other things, because in the vast majority of cases you will not want to bring a prosecution against a 10 or 11-year-old, and I think there's ways of diverting young people away from the criminal justice sector altogether beyond filtering, that you can achieve that without moving the age of criminal responsibility. So again, it shouldn't be that much of an impediment, I think, to some of this stuff. Sammy?
Thank you, Chair. Thank you for your presentation so far. Declan, in terms of a snapshot of current staffing levels at the Juvenile Justice Centre, would you be able to provide us with that today?
I probably wouldn't have the figures. I can give you overall that for the Youth Justice Agency, I mean, we are staffed for 318 bodies. That's what was published in various documents. As we currently sit today, through the voluntary exit scheme, we have lost 60 staff, and then through death in service, medical retirements, etc., we've lost in and around a further 10 to 15 staff. So,
is sickness an issue?
Sickness is an issue, and it's much publicised, I have to say, as well, insofar as the Youth Justice Agency and the department as a whole currently finishes bottom of that league each year with its high sickness rate. I have to say, from the Youth Justice Agency's perspective, we're seized of that, and we agreed with our board that we'd put an action plan in place. That plan's been in place from the 1st of April of this year. 1st of April last year, sorry. 1st of April last year, and since then, I mean, we've gone from 22 days sick at April to the most recent figures 15. So we're starting to have sizable impact, and that's because we've put measures in place to address what has been an issue for the agency.
You mentioned earlier on about the childcare ethos and the importance of that. Given the problems of low levels of low staffing levels, and the childcare ethos is predicated on appropriate staffing levels and suitably qualified and experienced staff. Has this ethos been undermined because of those issues you're facing at the moment?
No, and I'll say that with confidence, because the sheer volume of children coming through the justice system has reduced markedly. And I mean, if you take, for example, the numbers in any one day in Woodlands last year would have been 34. This year it's 25. If you take the amount of people going through the Youth Justice Service side of Mary's End, it probably has fallen by almost 50%, maybe not as high as that, but certainly a sizable percentage. So I believe that we've been able to cut our cloth, recognising that the numbers coming through the system have fallen, and to react accordingly. And I'm sure Paul will elaborate. If you take, for example, in Woodlands, then the numbers have fallen so considerably of young people coming into Woodlands that we've been able to use the staffing to get them more involved in a more end-to-end, 9 to bedtime, basically, that the staff are getting more involved instead of manning the houses, so to speak.
We would be staffed for 6 house units, 6 residential houses. At the moment, we've only got 4 house units operating. So we'll be able to manage the staffing levels and the children and young people within 4 houses. We have had 5 houses only open really since last May. So currently today we have 23 young people in custody. 2 of those are females, and the 3 male houses and a girl unit as well.
Yeah, I think it's the same in terms of the community side of the house as well. We historically have worked with about 1,500 young people at a time. Last year, in the total year, we worked with 900, so that's down significantly. And my caseload today, as we said, are 642. So if there was an opportune time for VES, this was it. I think we've been very fortunate in the timing, and I think that's to do with a number of reasons. First of all, demographics, that we have fewer 10 to 18-year-olds than we've had in years. And second of all, I think the system has gotten much better in diverting young people. So the young people we're working with are the critical few, if you like. And out of those numbers, only 5%, just to get back to a previous point, are aged between 10 and 13. And 2/3 of those young people are 16 and above. So you can see the system is shifting towards the higher risk young person, whilst other young people are being diverted away, which is nothing only positive. And again, I think we were fortunate in that we did lose 22 staff, but only 11 of those were actually frontline staff. So I would suppose say with a lot of confidence that children, victims, communities haven't noticed any reduction in service delivery or quality since VES.
And finally, Chair, you heard me with the previous panel that raised the whole issue of the Education Learning Centre. Could you maybe comment on that in terms of the reduced hours that the children are facing in terms of education provision?
I'll start and maybe pass to Paul. I mean, we recognised, and Sejini did report when they looked at Woodlands back in May, 29th of May 2015, that our education needed to be improved, and we accepted that. And it is true as well that the amount of hours that the children had was less than it had been the previous year. What we've set about doing is forging very strong links with the Department of Education, and that goes from ministerial level down, where they've been hugely supportive from basically the springtime of last year to say, what do we collectively want to do about that? And that has culminated, as you will know, in recent months, the announcement in December by the 2 ministers, where we've now rebranded the Education Learning Centre as an IOTAS, and we work towards that in May of this year. So I think we're making huge progress, but Paul will be able to talk more about the progressive routine we've been.
Yeah, if you like, I'll give you a quick update just on the progress since that ministerial announcement on the 17th of December. The education provision for young people in custody in Woodlands will transfer to the Education Authority. Officials from the Department of Youth Justice Agency and the Education Authority have been meeting to give effect to the transfer and to work through the various procedural issues. From that work, it was agreed that Woodlands should become an education otherwise than school provision, or known as an IOTAS centre, as provided for under existing legislation. Education Authority officials have also extended access to the Classroom 2000 network, or C2K, as is better known, to Woodlands. The transfer of the Education Authority will ensure that the children and young people in Woodlands have access to the mainstream curricular and extracurricular subjects that will assist in raising their knowledge and skills and their ability to function in the same way as any other young person when they return to the community. In terms of background, since 2013, the Education Department at Woodlands has reduced in size due to the NICS voluntary exit scheme, ill health retirement, inefficiency proceedings, a death in service and redeployment. This has resulted in a reduction of teaching and development hours. However, this has been supplemented by programmes and activities delivered by youth services, our horticultural project, and programmes delivered by a range of community and voluntary organisations and residential staff. Woodlands has ring-fenced the budget for all existing teaching and vocational instructor posts, educational resources and teaching materials. All vacant posts are intended to be filled following the agreement of the curriculum with the Education Authority officials. Woodlands will have a role in the selection and training of teachers to work effectively with children and young people to ensure that the education provision is effectively integrated within our care planning, assessments and other complementary social and behavioural arrangements. Overall responsibility for the teaching, the curriculum, assessment methodology, the educational corporate governance arrangements and the effectiveness and quality teaching standards will rest with the Education Authority. Since the removal of all under 18s from Hyde Bank Wood in November 2012, the profile of the young people in Woodlands has changed. This has led to a significant increase of young people admitted to ourselves who are post-school leaving age. Therefore, in conjunction with providing education for those of statutory school age in relation to essential skills of literacy, numeracy and ICT, we must also develop skills for life for those 17-year-olds and support and encourage them to prepare for the world of work, further education, vocational instruction and work experience opportunities. Youth Justice Agency officials and Education Authority officials, we have been consulting with mainstream educationalists and community practitioners on the development of a core curriculum and on a methodology for effective delivery. Once designed, the curriculum, the methodology for delivery and resources, and the monitoring required for service provision will be compiled into a service-level agreement between departments. Work streams have been established to focus on the following key areas: finance, legislative constraints, staffing and curriculum, and are on course to enable Woodlands to achieve EOTA status by May 2016. It may take a bit longer maybe to have fully recruited or resourced all of the teaching and vocational staff required. However, as an interim measure, temporary teachers, if found suitable for Woodlands, can be drawn from the Northern Ireland Substitute Teacher Register, or the NISTRA list as it is more commonly known. And with the attainment of EOTA status and with support from the Education Authority, we are hoping to implement a central learning hub of approved and scheduled activity in our learning centre. And through this partnership and the outworking of the core curriculum, this will ensure that the children and young people have access to mainstream education programmes and accredited training for future employment, but also at the same time have access to the behavioural modification and mental health interventions to support holistic development and higher level functioning. And to conclude, our core educational day in Woodlands will provide a learning and develop opportunities, vocational and work experience, but also challenge criminogenic behaviours, as well as to provide recreation and enriched. We're hoping to do it up to 6 days per week and up to 48 weeks per year as well.
Great, Mr. Stephen. Thanks very much.
Okay, no one else has asked for any questions, so thank you all very much. Appreciate that. Thank you. Okay, members, then we'll move on to agenda item 6. 2 members of the Maghaberry Independent Monitoring Board will attend to discuss the Tijini report on the unannounced inspection of Maghaberry Prison in May 2015 and other issues relating to Maghaberry. The relevant papers are page 136 through to 459 of your packs and includes copies of correspondence between the Chair of the Independent Monitoring Board and the Prison Service Director of Operations and the Chair and the Minister of Justice, which had been referred to by the Prison Governors Association during the evidence session 2 weeks ago. The Maghaberry Independent Monitoring Board annual report for 14-15 and the retrospective Hansards of the oral evidence sessions with POA and PGA requested by the committee were circulated to members yesterday and are in the tabled papers at pages 2 through to 89 of your packs as well. So can I welcome Margaret McCauley and Patsy McGonigal. You're both very welcome. Members of the Independent Monitoring Board. We're going to Hansard the session and it'll appear on the committee website in due course, just so you're aware of that. So thank you very much for coming along. If you want to outline a few opening marks and if there's any questions from members, which I suggest there probably will be, we'll take those afterwards. So whenever you're ready in your own time.
Good afternoon. Chair, Vice Chair, members of the committee. Firstly, I'd like to say the IMB welcomes this opportunity to highlight the concerns we've been raising over the past number of years. My name is Patrick McGonigal. I've been Chairman of IMB in Maghaberry since the 1st of April 2015. This is fellow board member Margaret McCauley, currently Vice Chair and Chair for the previous 3 years. Independent Monitoring Board, or IMB as it's was previously known as the Board of Visitors, and was set up under the Prison Act for Northern Ireland in 1953 and changed to the IMB in 2003. Board members consist of members from the general public from all backgrounds. They're unpaid volunteers, and I stress the word unpaid volunteers, appointed by the Justice Minister through competition. They're appointed for a 3-year term initially, up to a maximum of 9 years, in line with public appointments regulations. PMNOers, in response to a query relating to the relevance of the IMB, when there are so many bodies inspecting various aspects of the prison, stated that whilst an inspection is a snapshot of a prison during the short period of time, the IMB are in a unique position to report on how the prison is working, as they are on the ground 52 weeks of the year. The role of the AMB, which is an independent body, is to satisfy themselves regarding treatment of prisoners, the state of prison premises and the facilities available to prisoners to allow them to make purposefully use of their time. We consider requests and complaints made by prisoners. We attend serious incidents, which include deaths in custody. We report on matters of concern to the appropriate governor and, when necessary, to the Justice Minister. IMB are not inspectors, they're not investigators or managers of the prison. We're there to examine the treatment of prisoners, including provision for their health care and other welfare while they're in prison. And we're there to ensure that IMB are informed and visit prisoners on restriction of association and attend Rule 32 case conferences. We attend a sample of adjudication of prisoners who have been charged with an offence against prison rules. Board members also attend and monitor a range of meetings within the prison. For example, prisoner safety and support, equality and diversity, safer custody. And we're obliged to produce a report at the end of an annual report every year. To be able to carry out the role effectively, members need to have a wide knowledge of all activities within the prison and the roles of various associated organisations who work within the prison. For example, ADEPT, NIACRO, CRUISE, chaplaincy, etc. Although the AMB have no comparable responsibilities for staff and issues which affect those held in custody are a concern for the board. It is important that the AMB build a professional relationship with the staff in order to resolve issues. And where they can assist in resolving any difficulties, a member of the staff may have the board. Where it judges it appropriate, it may do so. I will now hand you over to Margaret, who will read our opening statement. Okay.
Good afternoon. Before I start, to make the distinction in our opening statement, local management refers to the staff at Maghaberry and senior management refers to staff at headquarters, e.g. the Director General and the Director of Operations. While we have raised several issues in the last 3 years' annual reports, I will concentrate on the main areas of concern, which have been staffing, healthcare and drugs. As Chair, from April 2012 to March 2015, we as a board have raised all the issues that were highlighted in the unannounced inspection report from May 2015 and failed to see why it seems to have come as a surprise to those at senior management level. Back as far as our 2012-2013 report, we highlighted the excellent facility in Donard House, which was often closed due to lack of staff. Staffing levels and the restrictions they consequently placed on prison regimes were again highlighted in our two subsequent reports, annual reports, 2013-2014 and 2014-2015. The present issues with staffing have been due in part not only to the circumstances over the past few years, but to the failure of NIPS to have a rolling programme of recruitment for at least the past 10 years. This is very evident by lack of staff with between 5 and 10 years' experience. When VER schemes started 3 to 4 years ago and when recruitment of new staff took place, adequate measures had not been put in place, retraining of new staff. The procedures for accreditation were not in place, which led to frustration on new staff who, employed on a lower salary scale, were dependent on the increment they would receive when accreditation was completed. The Director of Ops attended the board meeting in February 2014 and said that the University of Ulster Jordanstown is now on board to provide accreditation, which was long in excess of the 9 months new staff were promised. They were promised to have mentors on the landings, but the experienced staff were removed as far as possible from the landings and the new staff were left to cope without any guidance. I think you have copies of all our correspondence and the replies we received when we raised our concerns with the Director of Operations, but will briefly mention them here. On the 1st of August 2014, I wrote to the Director of Ops describing the situation then as critical. Experienced staff were leaving in large numbers due to VER, and newly recruited staff were also so disillusioned they were also leaving in significant numbers, approximately 40 to 50 at that stage. There were also plans to reopen Foyle to cope with the increase in prisoner numbers and to reduce the numbers in the other square houses. Shimla was opening and the drug recovery unit was opening in Glen House. Burren House was also opening and staff were under pressure due to the high levels of injury and stress-related sickness and the ongoing number of bed watches, which is totally unpredictable. In the reply dated the 28th of August 2014, the Director of Ops agreed that Maghaberry was below its target staffing levels, but blamed problems in sick leave, not recruitment. The Director of Ops also stated that recruitment was due to start again. This is the recruitment that new staff have only been interviewed for in the past few weeks. So by the time training is completed and staff are on the landings, it will be almost 2 years from that response. apart from a few, probably less than 20, that were recruited through PECS last year. I responded on the 18th of September and got a reply from the Director of Ops again that day, which we felt was totally inadequate, so we raised our concerns with the Minister on the 7th of October 2014. I again raised our concerns on the 27th of December 2014, and the response was very similar to previous responses. Before my 3 years as Chair finished in March 2015, I again raised all our concerns with the Minister, not only around staffing, but also the issues around drugs, healthcare and the cuts to other services that provide a vital service to the prisoners. When the DG attended a board meeting in April 2015, one of our board members raised the possibility of bussing in staff from other establishments to alleviate the staffing situation. While the DG agreed that this had been done in the past and could be done again, the difficulty was the cost. However, this was then done 4 months later when a new governor was appointed. When the new chair, Patsy here, took over, he again contacted the Minister in June with the board's concerns re staffing, the recent inspection and the serious incident of the fire in Erin House, which he will speak to you in more detail as he attended on the day of the incident. Following the publication of the inspection report in November, we again contacted the Minister to point out that we had raised all the issues to no avail over the previous 3 years. And just an issue on healthcare. The World Health Organization states that a prison sentence often entails an increased risk of becoming seriously ill or a lost opportunity to recover from an existing illness or dependency. Those who enter with a drug or other addiction or health-related problem often leave without having received proper medical care. It's a sad fact that individuals entering prison have a higher degree of severe mental health issues and existing medical problems. While there is no expectation that prisoners should have a more enhanced medical service than those of the public in general, it should at least be of a similar standard. Individuals often arrive in prison having been, quite legitimately, prescribed large quantities of medication, and when this is suddenly reduced significantly or stopped altogether, as by South Eastern Health policy, this can have serious repercussions. For example, withdrawal symptoms, anxiety, volatile behaviour causing disruption on the wing. Efforts to obtain such medication illegally, either by purchasing this from other prisoners or bullying more vulnerable prisoners to hand over their medication. Prisoners are frequently given 1 or 2 weeks' supply of medication, which both prison staff and the IMB have always argued creates more problems. Medication is a currency within prisons and can lead to debt, bullying, overdose, and the debt issue can impact on families outside of the prison environment. IMB have met with senior personnel in the Trust, and while accepting that their view on the dispensing of medication is that it should reflect that which applies to the community in general, the prison environment is not reflective of the general population. For example, the percentage of individuals coming into prison who are on medication is much higher than that of the general population. The number of individuals with addictions is considerably higher than that of the general population, and a significant number of prisoners suffer from mental health issues. IMB have constantly argued that the whole issue of in-possession medication needs to be reviewed. Staffing has been an ongoing problem for the past 3 to 4 years. This is staffing in healthcare, with the retention of staff being particularly concerning. The service has been running a crisis management for a considerable period of time, and this has impacted on the areas of preventative medicine and health promotion. Although the previously troubled relationship between the Trust and the IMB has improved significantly, the Board still finds difficulty in accessing responses to prisoners' queries. Even with the consent of the prisoner, the client confidentiality aspect of the Trust's policies is used, thus stopping information exchange. Over the past year, the IMB have referred medical queries to the Patient-Client Council to handle if there is an impasse. IMB are aware that there are waiting lists beyond that which applies in the general population for services such as dentistry, podiatry and a dietitian, to name but a few. The addiction services are overwhelmed with referrals, and the substitute prescribing element of the South Eastern Trust are not taking new referrals. At times, the only nursing element of their job that nurses were doing was dispensing medication. At the end of the day, whilst the direct healthcare aspect of Maghaberry is provided by the South Eastern Health Trust, the Northern Ireland Prison Service are ultimately responsible for the health and well-being of prisoners in their care. The growing numbers of older prisoners is also causing problems, as some require help with personal hygiene or mobility issues, and again we have raised that in annual reports. Untrained fellow prisoners are carrying out support duties to fellow prisoners who frequently have considerable needs. The fact that the drugs recovery programme only ran for 1 session, was hugely successful, and staff especially trained to work in the specific environment, is a great disappointment. With the drugs problem in the prison population, IMB would have thought that funding to continue this valuable programme could have been obtained. Drugs. While illegal drugs continue to cause problems, the issue of prescribed medication is also a major problem, as highlighted in the paragraph on healthcare. Prisoners are searched on arrival at the prison and on return from any outside facility, e.g. court, compassionate leave or temporary release. However, as long as prisoners can conceal drugs internally, this will only detect a percentage of drugs. There is joint PSNI NIPS initiative, which has proved very successful, and also intelligent-led searches on the use of drugs in detection. However, as drugs such as legal highs change so rapidly, dogs cannot always detect them. Prisoners frequently tell us that all drugs are available in the landings, and the delay in substitute prescribing means that prisoners resort to using whatever is available on the landing, often without any idea of what they're actually taking, which carries huge risks not only to themselves but by behaviour can impact on other prisoners and staff. Reduction of staff in the DST has meant that cell searches are usually only carried out if intelligence-led and not the random searching that would have taken place a few years ago. Again, this can impact on families outside if prisoners build up a drug debt in prison. I think you want to read a wee paragraph.
Just on from our previous AMB report, we just want to add this on the presentation. Alcohol and substance abuse. Illegal substances are part and parcel of the social problem. It's inevitable that such a problem will follow individuals into the prison setting. For many individuals, illegal substances are a way of life, and their use is seen as the norm. As AMB members, we have access to every part of the prison and regularly talk to prisoners and staff, either in the setting of the landing or whilst walking around the grounds in the prison. Prisoners talk openly about the availability of drugs, the boredom that leads to taking drugs, the drugs debts that they build up, and the bullying to hand over prescription medication. Naturally enough, the vast majority of prisoners will not report such bullying, and this can often leave a prisoner without his own prescribed and necessary medication. Lack of recreational or training opportunities contributes to boredom, which in our view often leads to the temptation to partake in illegal substances. On occasions when AMB members have pointed out to staff that a prisoner appears to be under the influence of some illegal substance, the response is often, "He's always off his head." There is still an acknowledgement by some, not all staff, that prisoners take drugs, and that's the way it is. Whilst it would be wrong to state that the Maghaberry is awash with drugs, there certainly is a drugs problem within the prison. However, it's clear from reports from AMB colleagues in other regions of Britain that this is not a problem arising solely in this establishment. As a board, we are concerned with both the quantity and accessibility of drugs, both illegal and prescription medication within Maghaberry. There is some concern, and there's an increase in prisoners who are failing drugs tests due to checks. We acknowledge that the cooperation within the PSNI has been of a great benefit and intelligence-led searches have been successful. We are aware that there are some prisoners who are intimidated into smuggling drugs back into prison after home leave, and that there are others who will do almost anything, include breaking into drugs cabinets to try and access prescription medication. Unfortunately, the misuse of drugs or other illegal substances does give rise to instances of self-harm and also contributes to other instances and management problems within the prison. There has been a re-emergence of hooch homemade alcohol in the prison. This has been found during searches of staff, or understanding that some of the fines are quite sizable. Those involved in the manufacturing process have already taken advantage of low staffing levels to work on and secrete their catches. Adept to undertake the addictions counselling have also got a waiting list with a growing number of referrals and their budget cut. They have introduced acupuncture to help prisoners who have alcohol and drug addictions in order to help with relaxation and aid sleep routines. However, this has been so popular that there's a long waiting list to get it for this type of treatment. In the previous year's report, we mentioned a proposed drug recovery unit. Glen House was chosen as a venue for the unit, and staff members were given special training to enable them to understand the recovery ethos. Drug recovery unit opened in 2014 and was delivered by staff from Adept and in conjunction with specially trained disciplined staff. Briefly, the aim was to tackle and address substance misuse, promote goals of recovery and reduce offending behaviour. The programme was very, very successful. Unfortunately, it was a victim to its own success because it didn't run again because of financial constraints. However, it's very apparent that one pilot programme has only taken place. It would seem to us it's such a good programme which is aimed at dealing with substance abuse, giving individuals the tools to help cope with relapses or thoughts of relapse, and reducing offending behaviour should be on a rolling basis. Having spoken to staff who undertook the training, who were so motivated and enthusiastic about working in the unit, it undoubtedly disappointed that the unit appears to be in limbo. A&B members have sat on several of the drug strategy meetings. However, in the main, these meetings have been poorly attended and actually haven't taken place for quite a long time. We have sent people to do that, and they've been there on their own, and nobody has turned up to them. At present, we're having such a problem with drugs and no drug strategy meetings, which contradicts itself. A&B have been raising issues of drug strategy at board level for many months, and we're hopeful that plans are afoot to re-energise this meeting, even if it stretches to a bi-monthly meeting. Margaret will take the finished part in conclusion of the statement.
In conclusion, I would like to point out that some A&B members, while en route, attend the prison in excess of 50 hours per month, and this is in a voluntary capacity, and are totally frustrated that our annual reports and recommendations have been basically ignored, and we would query the senior management even read them. And I'll give you an example in a following email. In an email to the Director of the South Eastern Trust on the 23rd of February 2015, the Director General criticised the lateness of our annual report, which was true. It was late due to changes within our secretaries, but it had been with them from the previous July, and stated that they were of limited value when produced so late. Our second point, and I quote, was, "We also agree that it would be helpful to have the opportunity to feed into the reports from a factual accuracy perspective. However, this is not the case, and these IMB reports represent the viewpoint of the IMB rather than any requirement that they are factually accurate." May I point out that our reports always go to the South Eastern Trust and NIPS for checking for factual accuracy before publication. NIPS have never raised any issues. However, last year, prior to the above email, we had a response from the Director of the South Eastern Trust, which I have here, querying some items in the report. We checked and amended one or two items before publication, but we also put a footnote in our report to say that SET had responded and disagreed with some of the content, but the board were content that for the year report our findings were accurate, and that is on page 23 of last year's annual report. Thank you.
Okay, thank you very much. Very comprehensive. It's reassuring to hear a reflection of society when, for a non-paid role, that there's competition for places. So I do thank you for your efforts on a voluntary basis in what is a very difficult role, I've no doubt, and dealing with some very difficult issues. Listening to your comments and reading through the emails, which were very, very helpful in terms of seeing for ourselves just the correspondence that went on and the length of time in which you've been raising issues, I think reflects some of the concerns that we as a committee have also raised. You know, whether it be about staffing levels, whether it be about how staff are being treated, about the low morale, about some of the incidents involving staff, around the drugs in the prison, around the healthcare, and there's also a reference to NACRO funding in your emails and your correspondence as well, which is again an issue that the committee has highlighted. I think it shows that over a prolonged period of time you've been regularly highlighting areas of concern that perhaps haven't been addressed adequately. If I could just make one comment before I ask you a few specific questions, and it was around your comments around the abuse of drugs within the prison. And I read, I'm sure not everybody read it, but Nick Hardwick also had a report on prisons in England and Wales, and it reflects something very similar to the McGabry report around how difficult this issue is. And I mentioned earlier that myself and Alban had been out looking at the idea of problem-solving courts and how many people with mental health issues or with addiction issues perhaps need to be diverted away from prisons, and there's better ways of dealing with them. But once they're in prison, it's in society's interests to get them, to get them off the drugs, because otherwise they come out, they reoffend again, or they have other issues that are there. And it is alarming to hear that there's not that type of work going on to actually invest in people so that when they come out they can get their lives back on track again. I think that is concerning, and is an area where I think it's worth highlighting again. Just if I can look at some of the particular issues that have been raised during the email correspondence, and I'm sure other members will maybe pick up on this as well. There was an interesting exchange which led to a reply from Paul Cockwell on the 20th of August 2014. And in that he mentioned, it was the 18th of September 2014, and he mentioned two issues after concerns were raised. He said one that gender was irrelevant. Now we've heard and read about how at times there's female officers being responsible for 60, 70, 80 male prisoners at a time. Would you agree that gender is irrelevant? Because it strikes me as much as women are very much capable of doing most jobs, when it comes to some physical environments, it may not be appropriate.
Chair, I would be as adamant as anybody that females are capable of doing any role, but physically, we have to admit, the average female is not as strong as the average male, and I know there's exceptions to every rule, but if you're leaving young females in charge of a landing with an adult male population, I don't personally feel it is safe. And I mean, sometimes we would have gone onto landings, a couple of female staff, maybe when it was back to 2014, when it was just the start of the recruitment, and you had females, you had all staff, male and female, with maybe 9, 12 months experience, and I don't think it was safe. I still don't think it's safe.
My view on it is that I don't want to be castigated for saying that women are not equal to men, but in the environment of a prison, it comes into play, so it does. I've been to unlocks in the morning where it's been a male and a female, and even with 2 people on the unlock, it is definitely not safe, so it's not. And a female in it is just not safe, in my opinion.
Even 1 or 2 men against 60 or 70 is not going to cope, so I suppose it's even more difficult. One of the other issues in the same email, he mentioned about how the drugs issue was improving, and this is a narrative that we have heard as a committee over the last, well, certainly in my time, the last 15 or 16 months. The Minister has gone to the floor of the House and said that the drug detection rate, the drug issue is improving. The Sagini report said quite the opposite. I mean, was there any evidence that you've seen in all of your time there that there was any improvement at any stage in terms of the abuse of both prescription drugs and illegal drugs?
I'll give you two things. I've been in some of the houses on a Monday morning where the prisoners have been locked, and it's quite obvious that they've all taken something along the line, and that is happening on a regular basis. No later than Saturday last, I was in the CSU, and there's quite a number of them at that stage of the game who have taken something. It hasn't improved, in my opinion. It's still talked about. It's a well-known fact. Talking to prisoners, you can get anything you want. Prisoners come into Maghaberry prison at the minute, and the follow-through from their own practitioner onto the prison healthcare schemes, there's a gap in there sometimes, and they don't receive medication. They automatically can go and source that medication, and that medication is always available. It may not be the correct medication, but there is also drugs there on it. So it hasn't really improved over the last 3 years that I've been there. If anything at all, it's got worse.
I'm also struck by the emails, and there was an email 27th of December in which you talked about the staffing levels in the landing, and you mentioned about the dangerous level of staffing. And again, this is an issue that repeatedly in my time as chair I have heard the committee make to the prison service and to the department about. We talk about a safe ratio. The headquarters staff, the prison service always tell you there is no ratio. It's about the environment, and I appreciate that for category A prisoners may be slightly different to lower category prisoners. I accept that. Nevertheless, I mean, when you say that there's 1 member of staff for 80 prisoners, irrespective of your view and ratio or what circumstances, it just doesn't seem safe. So when you raised issues like that, what sort of response were you getting? Do you think that they were being taken seriously, or do you think that there was anything done about it?
No, there's a short answer. The senior management want the landings to run with as few staff as possible. And in fact, actually, I would like to draw your attention, Patsy and myself met last July there was an interim director of operations, and at that stage we were concerned about so many landings operating at times with 1 people. And in fact, I won't name the area, but there is an area that is consistently operated with 1 person, and we actually raised the issue of a lone worker policy. The prison didn't have one, and coincidentally a draft one was issued the following week. And it shouldn't be the role of the IMB to check out a lone worker policy. That's not what we're there for. Yeah. But there's lands are still operating with too few staff, and it's not even a case of needing more for Category A prisoners. Category A prisoners can be the calmest. It's maybe young and volatile and in on short sentences on remand. They're actually maybe more volatile than actually lifers.
I would agree with the line that there are certain houses where you would get away with less staff on it, or you get away with a minimum of staff. But there are houses on there at the minute that are completely understaffed.
And one of the other things that we've heard, particularly in the last month or two, has been, well, look, you guy in there, things are improving already. We expect to see improvement in the next 6-7 months. In terms of I know it's difficult in such a short period of time, but have you seen any improvement in the last number of months since Phil Ragg has moved in as governor?
Well, we kind of anticipated maybe being asked something like that. Yes, there's been a few changes. The core day has been implemented. Yeah. There's a new canteen for staff, which actually was essential. They've strengthened the senior management team, and the biggest plus was the fact that he was able to get 50 extra staff immediately. Previous governors had cried out for extra staff and were always refused. And if it would certainly been a different situation if they had got that extra staff. Some of them were detached duty, some of them were permanently transferred. Again, if you look at the figures, staff, there were a lot of staff off on sick leave when he came in. Yeah. The majority of those staff are now medically retired. A lot of those staff, I think, maybe when the Director General was here in November, was just reading over the Hansard report for it last night, and she said there was actually 57 at that stage had gone. So they are off the figures. Staff who were off and are going to come back to work. They've already, at that stage, they've had their 6 months full pay. Financial reasons are putting people back. They need the full pay, or maybe the 12 months they're going to be without pay. So they're coming back regardless of whether maybe they're totally fit to come back. So that is obviously affecting the numbers. Also a big difference now, possibly due in fact to the wranglings with legal aid. There are less prisoners coming in. When the prison was at its worst, probably in 2013-14, there was almost 1,100. It's now down to 200, 250. You know, it's around the 850 mark at the minute. That makes a big, big difference as well. And of course, one big advantage that the present governor has, and I do say total respect for what he is trying to do, but he's in a very fortunate position. He's wearing two hats. Yeah. He's wearing the hat of Governor of Maghaberry and the Director of Operations. Not only the previous governor, but the previous two governors, anything they would have went to, anything they wanted, they would have had to go to the Director of Operations, and it was invariably refused. Now, I mean, are you going to refuse yourself something? Yeah. It would be my short answer. Yeah. And I suppose a negative is because he's in two roles, he's not there full time, and I think maybe to turn Maghaberry, as I say, and he will work. I mean, will work, and he is definitely trying to turn around. But you probably need somebody there full time. There's other things that's happened. I mean, the Quaker Centre lost a tender. That's been a big disadvantage in the last few months because that provided a very, very valuable service to prisoners. So, back to staff, and last week I asked on Friday, and there were 63 staff down again on Friday. And so I think if you actually sort of sat down and did figures, in some ways there's not a huge difference in the amount that's often sick, and yet it's supposed to be being managed differently now.
I suppose we'll see when the Jenny come back with their report on last month. We'll see if they believe this month they'll believe if anything has changed. Though I'd imagine that in the short term, when you know an inspection is coming, you spruce the place up a bit to make sure you have the staff there. And I think that's why I made the point I want to see regular inspections over the next year to make sure that things stabilise and settle down. Just a couple of questions to finish on. The fire at Erne House is something that, again, I don't want to go into too much of the detail in this because I think a report is coming out probably within the next week or two, and I don't want to get into the detail, but were you called to that event? So you were there when that happened?
I wasn't.
I was involved on that, and I attended the fire. By the time it got there, the fire was out. But I'll give you my timeline on the day and any facts that I can give you that surrounded the whole thing on it. I got a telephone call just after 12 o'clock on the Sunday morning. They say that a number of prisoners were refusing to come in from the yard in their house. That was from the duty governor. I asked if they required anyone from the AMB because they phone us when what they classify as an incident takes place where they need somebody to come up. He declined and said that expected to have the matter resolved within the hour. So I rang back 50 minutes later and asked was the matter resolved. And he said it was still ongoing, but hoped to have it sorted out shortly. I got a further phone call. They said that the prisoners, an hour from that, or an hour and a half from that 12:50 call, I got a phone call to say the prisoners had started a small fire and that things were now at gold command stage. I later got a phone call from the number 1 governor at 4 p.m. telling me to send a member of the AMB that there was now a major fire. I contacted the 2 members that were on road along with myself and they set off to the prison. I arrived at the prison shortly after 5 o'clock. On arrival, the fire service, there was 6-7 fire engines outside. The place was hung over with smoke. A lot of smoke in the area and a number of personnel. At this stage they were starting to pack up, so they were. When I got through security and into the prison, I contacted the other 2 AMB members who had got into the prison before me and we proceeded to Erin House. DST were there along with a number of officers from the wing, and I did notice that the officers from the wing were distressed and that some of them were suffering from smoke inhalation or whatever, and some of them were in the process of getting ready to go home. The fire service was still there mopping up, but the place, the whole entrance and the reception to the entry of the storage area was badly burnt, and we were allowed access down under it. There was 3 inches of water on the floor. It was just a fire scene that had just been put out. There was still wee pieces of smouldering, there was smoke and the smell of chemical in the air. After we went up the stairs with the governor and we discovered that when I got up the stairs I discovered that all the prisoners were still locked in. Now, the building in itself was very, very warm just after a fire. The fire had only recently been put out, and as I say, the smell and the smoke in the place was still hanging about there. We observed and food and water were given out. Each prisoner was unlocked individually and food and water was given to him, and requested did he need any help or whatever. A number of nurses from the healthcare arrived with various bottles of oxygen, and they proceeded to go down through the wing on it to see if anybody needed anything at all on it. We observed there for another 30 minutes, just what was happening, and we went to the duty governor and director's office for an update. We were updated by him and the number 1 governor. We were told that the thing had been taken over by Gold Command and that there was a number of discrepancies and the time from when requests were made to Gold Command to shut down the situation. Basically, what we were told after, what we've been told from the prisoners, that the prisoners had said they wanted to come in. It was an April day, and there was a lot of rain, and then the sun would come out. It was a bad day. They had decided they surrender, and they had made the people on the front face aware of the fact that they were going to surrender to come in, but they were told they weren't allowed to surrender because there was no surrender plan or intervention plan being made up. Intervention plan, and they were told that they would have to wait. During this waiting period, they decided to burn the store, and that's when the main fire took place. The questions that we asked of the governor was, why had it taken so long to get the situation resolved? Why were prisoners not taken to the secured playing fields out of the cells? And why, when the protesting prisoners had decided that they were to come in, they were told no, that a number of protocols had to be first agreed by the Gold Command, and this would take time. Basically, who was in charge of this whole incident? And we were told that Gold Command had taken over the whole incident. We then proceeded to our own office and we read up the book on major incidents, and we'd put down basically those three years there, which each of us had seen and what we had witnessed and what we had been told. I was concerned the following morning that when I read the newspapers that they said that there had been a minor fire in McGabry. I can assure you it was not a minor fire, and it's only a miracle that nobody was killed or nobody was badly burnt. We expected an internal inquiry into the thing. We never were approached about an internal inquiry about it. I'm totally unaware if there was an internal inquiry on it. The only thing that I know now about the inquiry was approximately 5 weeks ago we were told there was going to be an independent inquiry, and we talked to a guy from that there, and myself and one of the other AMB members, and we went through the points on the day that we had seen. I give him a full factual of what I had seen in the day, and that's the way it was left with me. Who was in command, who wasn't in command, I can only go what I was told that day.
I think this is one of the most worrying aspects of this whole thing. I mean, I agree with you that I think there were efforts made to play down the significance and the magnitude of the fire and the damage that was caused. I think that's something we've highlighted on the floor of the House with the Minister as well, that there was attempts to play it down. But I always get concerned when we hear so many conflicting versions of what actually happened. I don't know what the truth is. I wasn't there and not privy to all of the information, but it concerns me when we hear so many different versions of what happened. And we were given evidence that prisoners actually tried to surrender 3 occasions during the period. Now you've said that you were aware they tried to do it once. We were given evidence that they tried to do it 3 occasions. Now if there is a delay and somebody is not able to make a decision in terms of how they see that carried through, that is concerning to me, as is where the delay was caused. Now whether the delay was caused at Silver Command or Gold Command, I think that's something we need to find out, because there's no doubt that delay has helped cause the significance of the damage and the cost to the public purse. And I think it's really important that we find out where that delay was, whether it was in getting together an action plan to submit it to Gold Command, or whether Gold Command sat on that before they authorised action to be taken. But I think that is a really, really serious thing that we need to look at. You mentioned you have spoken to the people who were carrying out the independent inquiry into this. Okay.
I did, yeah.
Okay.
It just, I don't want to criticise anybody about their report, but the guy that spoke to myself on it was more concerned about there wasn't fire drill procedures put in there, and that NIPS could be held liable for corporate manslaughter if this ever happened again. And I got the feeling that he was more concerned with the structure of the prison end of it, not actually concerned with the exact timeline of the fire. Okay. I can only tell you what we were told on the day. Who was responsible on the day, we don't know. I don't know. But I was told it was Gold Command, and I had to take that at face value. That's what it was.
Look, just to finish off before opening up to other members, when you're doing voluntary work, you're volunteers who are fulfilling this difficult function. Do you think that you're taken seriously enough by management within, and I mean senior management in the prison service? I mean, do they say, well, yeah, look, I hear what they're saying. They're more of an inconvenience than anything else, and like, you know, we take our orders from elsewhere. I mean, or do they actually listen to you and say, you know what, that's a fair point. We need to do something about that.
There's a consensus at times from some of our members that we're not taken seriously. So much so that we bypassed the prison and went straight to the Minister of Justice with letters at times, because we felt that. We had a run of 5 or 6 months when a number of members left, and people were beginning to think we weren't being taken seriously. But we must be taken seriously, because the number of phone calls that I got yesterday from various people about what I'm going to say here today makes me think that today they're taking me seriously.
Yeah.
On a day-to-day running of the prison, I think you are taken seriously. If you raise a complaint about a prisoner not getting what he's entitled to, or if you see a situation that's not correct, it is taken on board. You may have to bring it up a couple of times and put it in the minutes and set the minutes down on the table. But as an AMB member, and I've looked at the minutes. My concern with the minutes is the minutes stop with the Governor. I think the minutes from the AMB meetings should go further on up the management chain, because from the minutes of the meeting, a pattern will emerge, and This is a second load of people saying about whatever is happening, and I think the minutes of our meetings, our reports from our meetings should go further on up the management chain, because it's not happening at the minute.
When you said you got a number of phone calls because they obviously took you seriously when you're appearing in front of the committee, who were those phone calls from? I don't even need a name, I just mean what organisation or whereabouts.
The Northern Ireland Prison Service.
Right, okay. Okay, Raymond?
Thank you very much, Chair. And can I echo the comments the Chair made about in terms of voluntary contribution in what obviously is a very difficult, because there's competing views of everything, so these are in the middle. And I want to stress, I mean, certainly I'll not be asking you any questions that makes you feel that you're the adjudicator of this, and just trying to get a better picture, because obviously one of the reasons why you're here today is around the Jenny report, and we've seen the fall event. And I just want to first of all explore the relationships. Did you talk to the Criminal Justice Inspector when they were making their report as a body or as individual members?
We wouldn't have spoken to them. We would have spoken to them, just whoever was there. It was actually Patsy would have spoken to them this time.
On the days in question,
did they approach you officially as chair, or just because you happened to be in McGabry in particular?
No, they approached me as chair. There was a time set for a meeting on it, so they did. And I was on that day, so I was as well on Rhoda.
Okay. And in terms, because I mean at the end, I'll just refer to that. So the minutes of your meeting are only given and seen within the prison.
That's correct.
Okay. The relationship with the governor, the governors, and I'm talking about the governor in terms of the senior management team, not an individual. How often would you have met with them as a body?
Are you talking about the governor within the prison?
Yeah, in McGabry.
The governor in the prison attends our monthly meetings.
He comes to the monthly.
Yes, and I mean we've always found that. Well, I mean, even the previous two governors, I mean, their door is always open.
Yeah. And did he stay throughout the meeting, or would there have been a private session if you wanted to discuss something, say, affected the individual there?
Well, if you saw the agenda, when it comes down to the chairman's business at the end, the governor at that stage usually leaves. He leaves for the last 10, 15 minutes of our meeting.
Okay, and in relation to the relationship with the senior management, which you described in, say, headquarters, would you meet with anybody in headquarters on a regular basis, a statutory basis, or is it just casual?
From April, we've had the senior manager or the director has been to 2 meetings. One in April. Sorry,
one in April and 1 December.
1 April and 1 December.
And was there any particular reason for that, or just just the way it bounced?
Just the way it. We just got told a week before that that there would be.
The fire was in April. Was it before or after the fire?
It was before the fire.
Before the fire, okay. And in terms of membership, when you're a member of the board, it's for one prison. It's not for. So you. I don't mean this in terms of. So you have no understanding, say, of unless you've been one, you have no right to go to Hydebank or McGillicuddy.
No.
It's only through McGarry, so you have no sense of different management styles, and you can't compare and contrast.
No.
Okay. In terms of just you were making observations about staffing levels, and obviously that has been a regular feature over the last while here. Does there be explanation given to you if you're on a wing or in a block or in a house and you notice or have an observation you think it is understaffed? Does anybody take you in and say, here's how we have managed this?
On most occasions, when we see that there are very little staff, we will go and say what's going on. Why is there little staff? We'll go up on the duty governor and make the point that we have noticed today, and on every one of our meetings. If I can facilitate it with a copy of the minutes, on every one of our meetings, we always criticise that there are a lack of staff. Over the last 12 months, every minute there's been a lack of staff. We get a list read out to us of who's on that day and a lack of staff. And what they normally do, they'll rejig the whole prison. They may take someone from search, they may take someone from reception and put them on as landing people.
Okay.
Could I just come in even there? Just by that, sorry, but just by rejigging staff, you're depriving in other areas. So, say for example, you take somebody from visit reception. That impacts on the fact then the families have left in, say, maybe clothes, maybe whatever for the
Parcels.
any parcels.
Yeah.
So if they're taken from the visitor's chair, it could be days. Maybe somebody who's just been newly committed to prison, went to court, wasn't expecting a custodial sentence. Families leave in clothes. That could be 3 days, 4 days, 5 days till they get a change of clothes. And it's taken from the letter centres, they're not getting their mail. You know, it impacts, yes, you're covering maybe the landings, you're firefighting, but you're taking them from one place. You know, you can only make X number of bodies go to X number of places. You know, you can't make 10 people cover 20 posts. Simple as that.
But you build that picture up as you go along. Nobody brings you in and says, look, say a regular feature is the number of lockdowns. And,
no, nobody brings us in directly.
Nobody brings you in. Okay. Just in terms of in relation to the document which you sort of referred to for the fire in their house, was that given to the independent investigators?
I give him the timeline of what I'd done that day, yeah. I gave it him orally, so I did, and he took it down.
He took it down. And, I mean, there's obviously a number of observations which you've made. The chair's right. I don't think we want there's an investigation and we'll be in a better place. And, I mean, you obviously give it the facts as it happened to you, and that's fine. I don't think anybody's going to want to even ask or not ask questions on that. But in relation to him, the chair's made the point, the phone calls that were made to you yesterday, do you think they were undue phone calls?
Yeah, I do think they were undue. I think I needed them phone calls.
I mean, I think it was, as the chair, you should make that known to whoever you feel appropriate, because I don't think whatever people's views, or I don't think anybody should be trying to put undue pressure on anybody for any reason, whatever the reason is, and I don't want even that they ask you, because I can remain private, but I don't think it's proper that it's done. I mean, I think your reports and the information you've provided us, because I mean, whatever, and I think we all have said this, the report has brought up a focus on this, and I think that whatever the outcome of the fire investigation, and I think, we're all in a better place to make assessments than we just maybe with the outcome of that before. But again, I want to thank you for your frankness today, and also obviously for the difficult work that you carry out. So thank you.
Thank you.
Well, thank you, Chair. Thank you very much for coming and giving evidence to us on what is a very serious problem, which we are taking very seriously, despite what some of the Prison Officers Association might think when they were here that day. But first of all, the phone calls. Again, I'm not going to push you on it, but the very fact that you're receiving phone calls the day before you come to this committee smacks of an attitude, an aptitude that maybe has got us into this problem in the first place. Do you think that, how often would they pick up the phone to you on the daily running of Governor's job or senior management job to seek advice or to seek your thoughts on something or anything?
I'll answer that, Andy, and I'll answer it in a funny way, Andy. We have complained about them not phoning us from the prison. We've complained from the prison where a serious incident has taken place no later than Friday night. Last Friday night, a serious incident took place where we weren't phoned. We weren't. Now, we are part of our remit that we're told when there's a major incident, and there's been a number of incidents over the weekend period which we haven't been phoned about. So we complained about not being phoned about incidents, and then all of a sudden they get phoned about other stuff.
They're obliged to inform you?
There is an agreement there, whether it's a legal agreement or not. They are obliged to phone us if a major incident takes place. Previous governors would have phoned you there to be as a witness. You see, when prisoners were transferred from one place to the other, that nothing happened, and that's the reason. And maybe you were there at times, but we were there just to make sure that prisoners were treated in a proper manner.
Can I just ask, and I don't want this to become too technical, but your previous times that you were asked, would they have been internal to the prison, or would they be what they call gold command situations?
ECR, the emergency control room, phones us of this incident. Now, Patsy and I would have had met last night to sort of go over about today, and there was a call on my phone when I went back home, and I'd missed one on my mobile. There was a minor incident last night. However, there was a major incident the night before, and I was contacted at home by that. But this always, it's not from. It may be the duty governor in the night that contacts us, but it's usually whoever's in the ECR that contacts us to let us know we're on the checklist to be told.
And the definition of major, what would?
Well, say for example, maybe if you've maybe a lot of prisoners refusing to lock and it's turned into a major incident, maybe threat to life, maybe a fire. It depends probably maybe even who's on duty, what the perception of maybe if a serious incident is. I mean, sometimes they just phone you to let you know. You're not really expected to attend because it's going to be cleared up so quickly that by the time you would travel to the prison, it's sorted. But they just make you aware about a courtesy call.
Are you aware, obviously everyone's aware, it's in the public sphere, of the prison-on-prison assaults and the large increase from March 11 sitting at 45 increase, which was a massive increase even then, to jump up into the hundreds and then into the mid-hundreds. What do you put that down? Because there's stark, that rise between April 10, March 11 to March 12, it went from 45 assaults to 104 assaults, prisoner on prisoner, and then from the year after it increased to 138. There's that 1 year of marcation where you can actually see it as went back to double. Is there something simple that you can put your finger on and say, this is it?
The majority of incidents like that take place because prisoners are being locked up 22, 23 hours a day and they have no regime. You have guys who are locked up all day long, haven't got a shower, they're in a cell with another guy. They're unlocked for their to be fed. Their dinner would have been served them at 3:30 in the day. They can't get out to make a phone call, to phone the wife or to phone the girlfriend or to talk to their children. Just the whole thing is shut down. That was because of lack of staff, and that primarily. This has been boiling in Maghaberry for quite a while, and it come to a point that come to a head basically at this fire, and it was accepted then that they seemed to be accepted anyway. There's major problems in there, but that's one of the major reasons why assaults took place. Frustration.
I would also say too, I know I'm there. I mean, it's been sort of 6th year there. I think the types of drugs that's coming in has increased. And I mean, I'm certainly no expert in what they're taking or the mixes they're taking, but some of the drugs that are coming in seem to actually make them quite violent. You know, there's been cases, I think it was 2 years this July, there was a batch of drugs came in and there was an absolute spate of self-harm, even prisoners who normally, I mean, there's obviously always a lot of prisoners in there who self-harm, but this was prisoners who normally don't self-harm, and whatever was in it, the effect it had on them. So I mean, you're talking about it, as Patsy said, the frustration probably being locked up. I know the evening meal is now being served a bit later, but it's still a long time if you've no staff and you're locked up and you're maybe in a cell with somebody that you don't really get on with. It's a long time to be sitting with them.
And I suppose if you have a bad batch of drugs, for want of a better word, going into a concentrated area, you're going to feel that in practice and habit, and it's going to place a greater burden on the staff that's there.
I'm sorry for interrupting you. Just before we move off that point, it's interesting around this sort of being locked up for so long. So the introduction of the core day. I mean, just to give us a flavour of what that means. So the core day then is establishing a routine within the prison day. So, you know, you're out for a certain period of time, you'll get washed at this sort of time, you'll get your dinner at this time, you'll make phone calls. And I mean, that obviously is helpful. It's something which is in regular occurrence in prisons and GB. The core day, which maybe hasn't operated in Maghaberry, is that going to help in terms of the frustrations of the prisoners who are locked up all day? And is that working in terms of how it's been established recently?
If it's established and it's maintained, it obviously will help, because at least, you know, if the prisoner actually knows that he's going to be locked on a Tuesday night, so he could explain to his family, say to be wife, girlfriend, children, whatever. But it leads, obviously, to arguments if they planned a phone call to, say, to the wife.
Yeah.
Don't get the call. She's sitting home waiting for a call. She doesn't know whether he's locked, whether he hasn't bothered.
Yeah.
And then the next phone call, there's Roy. That's bringing it in. They're shut all night. And it's just, you know, it's when you're in there,
Yeah.
things that may not bother you outside because you've 100 other things going on, but a minor frustration
Yeah.
in prison becomes a major thing because you've nothing else to concentrate on. And it's very hard to understand maybe the concept of that. Is you're going to work, you're rushing, you're doing, but if you've nothing else to think of, I didn't get my phone call.
Yeah.
And that's why a minor incident becomes, and then it impacts on everybody in the land.
Sorry.
No, you're okay.
Just to qualify a wee bit more on that, we have made a point of asking as a Corday working, and at our last meeting with Phil Ryan, we wanted to know as a Corday working, and we've been around most of the houses checking with prisoners under to see if their Corday is working, and they've highlighted wee bits and pieces that, but it seems to be coming around. It's one of the best things that's happened for quite a long time.
We were only told here by the officials, we are only told what we ask and what they answer. And that's been part of the problem. There's been this prevarication and we're only told half the thing. And so I must say, Margaret, your emails and your exchange, your trail there is very, very refreshing and informative.
Thank you.
And you hit the spot every time with regards to your complaint, but the answer you get back is the same old, same old. Now, you talk about it in human terms. There was 2 dates specific that jumped out for me. 17th of September 2014, one young female was left on her own on a landing with approximately 40 prisoners in Row House. And on the 27th of December, you seen fit to email Paul Cockwell on the very same day you seen this, you witnessed this, that one staff member was in Bush House on managing 2 landings with approximately 80 prisoners. Now, that's very strong. That gives you a real sense of what's wrong.
Yes.
But they're just 2 snapshots. How often is that happening where you've one staff member on a landing?
Well, as I said earlier on, there is one part of the prison which I'm not going to name that has permanently one person on at night. Frequently, no longer ago than Saturday, Patsy witnessed one in Doyle House, one person managing 2 landings. And if everybody's locked and everything's grand, short term, for an hour, somebody going for the lunch, somebody going for, that works. But if anything happens, bells ring, there's an emergency. If the staff need to go around to do a regular check, if you've got spars on that landing, and that is the big one, especially somewhere like, say, Ban House, which is the induction house, you frequently have quite a few people in there. They're just into prison. They're on spar, which is supporting people at risk document. I'm sure you're aware of that. A lot of those are supposed to be maybe 15-minute observations, half-hour observations. It would take a member of staff on their own to keep going round to do that, because it's fine. It's like everything. It's fine until something goes wrong. If you're running around to see maybe 6 people, you speak to somebody, you go round. By the time you get to the last one, you're not going to get back to the other one in 15 minutes. And worst case scenario, somebody takes their own life. So prison ombudsman's in. They were supposed to be checked at 15:15. They were supposed to be checked at past. And it's a slip 5 minutes. It's only 5 minutes, but it's 20 past. The next one slips 5 minutes. It's said to be seen 4 times an hour. The down has been seen 3. And it's those things that we have the concerns about. You know, it only needs... Prison changes very quickly. It can be very calm. Everything can be grand. Incidents kick off so rapidly. And that's where the problems arise. If you don't have... there was an incident, I think probably about a year and a half ago in Hyde Bank, when a young officer was dragged into a dining room and very badly assaulted, and only for a member of... It was not prison, it was part of the works team, I think, that discover, I mean, we would have known what was the outcome.
I'm aware of that specific case. I'm also aware of a case a number of weeks ago where a family in my constituency, son is an inmate in long term. He's not a young lad anymore. He was very young when he went in, and he tried to take his own life a number of weeks ago, and it was all to do with drug taking and bullying. Now he certainly didn't have a drug problem when he went in, but I'm sure he's coming out with one.
Yeah.
And he's due to get out very, very soon, but yet he tried to take his own life. When incidents like that happen, are you briefed on it? Are you briefed on the detail of them? But with either the incident with the prison officer being assaulted and dragged in, and the near death?
If there, it's not being flippant, but there are so many. Nobody realises how often the staff actually save people. You know, it's like when you're right, nobody remembers, and when you're wrong, nobody forgets. And the fact that there would scarcely be a week in Maghaberry, what there has been a ligature cut, somebody's been cut down, has had a ligature, there's been a serious incident of self-harm. I mean, sometimes we hear them, sometimes we don't. It just depends who's in, depends who you're talking to.
But there's no protocol. There's no protocol.
If it was a very, very serious incident of self-harm where, you know, somebody becomes unconscious, they may be taken to an outside hospital, there's going to be maybe a brief about a cold debrief, or one of our members attends a safer custody meeting on a Wednesday morning, and cases like that will be all brought up and they're discussed pretty well there. But to be honest, there are so many times that only for the staff there would be more lives lost.
Yeah. You as chair wrote to the Justice Minister, and you got a response from the Justice Minister. How do you feel about that response? And was that unprecedented? How many chairs of the IMB felt the need to write to the Justice Minister?
You tell which date was that?
Sorry, the date was the 7th of October 2014.
Was the staffing issue again?
You wrote to the Minister about the current staffing levels and the increase in assaults, and you were basically making him aware of the problems that you were finding. You did get a response on the 21st of October, but again, having read the response, he was basically telling you to keep going, keep doing what you're doing, keep communicating with Paul Cotwell.
And it was by perception?
Yes, I seen that very clearly. However, I note your concerns about the perception of safety at the establishment. How did that make you feel?
I think it just made you feel the same as you felt when you got the letters from the Director of Ops. You know, we can only raise our concerns. We have no power to do anything about them. So, I mean, we raise it to senior management. We raise it at monthly meetings with the governor within the prison. We raise it then, as I did, with senior management. The only other level we have is to go to the Minister, and we can only keep raising our concerns. Unfortunately, we have no powers to do anything about it. We highlight it in our annual reports, which sometimes you query who reads them. We put in recommendations. Back maybe 3, 4, 5 years ago, whoever would have been Director General those days would have actually responded to recommendations. We don't even get a response to them now, and we're putting in the same recommendations, probably report after report, and it is very frustrating.
I know you'll be doing good work on the ground, but do you feel irrelevant when it comes to the officialdom in the prison service and the Justice Department?
On the level that within the prison, I think we have a very good relationship with the staff, you know, within Maghaberry. And certainly would have no hesitation going to any of them. You know, if you have concerns about a prisoner, can go there, go to the governors within the prisoner. But I think once it goes above that, and I read you out a bit of that email just in my opening, and I mean, I think you saw exactly, you heard exactly, you know, that what was it that you know, they represent the viewpoint of the IMB rather than any requirement so that it to be accurate, and yet we send them for accuracy, we check them, and then it goes on sort of about...
Just on that point, you're an independent monitoring body. You're volunteers
Yeah.
also, which is very important. Do you actually have to send them to the Trust and the Prison Service to check for
accuracy?
Accuracy.
Well,
how does that make you feel, and how does that make... surely that doesn't sit well with your independence.
Well, in some ways it gives more weight, because at least we know that, I mean, say we say that there's a clinic that's not running, and they can actually say, but yes, that is running. So at least what we're putting out is right. Certainly, you know, our perception, if we felt that, you know, attitude, I mean, or staff and things like that, we certainly wouldn't change that. But if they said to us anything that they can sort of say, you know, yes, we are doing that, we could check back and we realise, oh yes, well actually they are. You know, it gives our report maybe more weight because we know it's right. NIPS have never challenged us on anything.
Have they ever asked you to change something that would be seen as perception?
Who?
NIPS.
No. NIPS have never asked us to change anything in our reports.
When did they stop replying to your recommendations?
They've never replied. I was chair for 3 years, and there was never any replies to anything when I've been there.
I think we need to find out just exactly why. I think that's something we maybe ask them. Why they don't respond.
On the report for the year for last year, there's in excess of 30 recommendations. And if you go through the inspector's report on it, the majority of the recommendations are on the inspector's report. It's basically near enough the same thing all along. So last year, that report and the inspector's report worked the same thing together. So it was exactly
so whilst they might think that it's a bit of duplication, it would be easy enough then to respond to you. They'll be responding. They could use the same speech bubble, basically.
Well, you get the feeling that things just go so far and then nobody looks at it after that there.
Okay, thank you very much for your time.
And I think it adds to the credibility, given that you're highlighting the same issues that were highlighted in the Jenny report. You know, so anybody who wasn't taking you seriously at least can see, well, you're highlighting exactly the same issues and you've been doing it over a long period of time. So
I mean, I would have went through the report.
Yeah.
And I mean,
glad you read it.
I've read it. And I mean, I've found a few inaccuracies. But I mean, I've ticked off so much in it that is actually exactly all right. They're paid, we're not. So it's in more detail, but no difference.
Yeah,
thank you, Mr. Chairman. Just picking up on that theme there, and also just thank you for your honesty today, because it's been quite refreshing in terms of a lot of the stuff that we've heard about Maghaberry Prison over the course of the last the last year and a half. I've been on the committee. You know, people sitting at where you're sitting today, misleading this committee. We were told that recruitment was going to start just last March. That it was going to start the next week, and it never happened. And indeed, I had to fill up the Director General herself, and through the trade union with information immediately after it was presented to us by the Director General. I had to admit at the next meeting that was untrue. So having a bit of honesty brought before us is something which is greatly appreciated. And you know, as I look at the letters here, you know, you're indicating about the safety of prisoners, you're indicating about the length of time that they're locked up, about the drugs, about the lack of use of facilities that prepares prisoners for the outside. And you know, then all of a sudden we get this shock report. But I wasn't aware of these emails, but obviously, you know, the Director General, the Director of Operations, all of that team were fully aware of it.
Yes,
so it appears it hasn't been acted upon.
It's just you get a reply and it's totally forgotten about. And as I say, we've been replying. I mean, that's from August 14, so you're over a year and a half now. I mean, the recruitment there were some that came in, I think, through PECS last year, but I don't think it was even 20. And they were to keep a list from that recruitment drive, which seems to have lost. And I've been told informally that in the 2015, and again, I don't know how accurate this is, but in the 2015-2016 budget, they haven't allowed for the salaries for the new recruits. So the ones who have their interviews completed will probably not be going to training until April, unless money is found from another source. Will not be starting training to April of this year, which means it's going to be probably the end of the summer, which is the hardest time before they're actually on the landing.
It's and the thread in your letters as well is that lack of staffing is leading to the lockdowns, it's leading to a lot of tensions, leading to prison officers being left vulnerable because there isn't enough of them, and it's leading to prisoners being vulnerable because there isn't enough prison officers to actually manage it.
That's totally correct.
That's the thread that's here, and that's what seems to have been completely ignored, that we need more staff, there's a cry for more staff. Sickness levels are actually going up because you have a lack of staff, and the stress levels are obviously going through the roof as a result of it.
In some of those emails from the then Director of Operations, he talked about that, yes, they were below the target staffing levels, and that there was overtime to cover them. But I mean, as you would see from my letters, I point out, if you've been in there for 12 hours, stressed, coping with what, the last thing you need is more of the same. You need your rest days to be fit to cope with the rest of it. Yeah. And there may have been overtime to cover the lack of staff in post. There was never overtime to cover sick leave, and there was never overtime to cover bed watches, and that is so unpredictable. I mean, you could have 3 people out at hospital today needing a bed. That's 4 staff for each, 2 for each shift, 3 for each of a Cat A prisoner. There could be a major incident in a couple of serious cases of self-harm. 3 more people. I mean, I've seen 6 ambulances in there in the one day. So there's 6 4s, there's 24 staff that needs to be covered. And again, it's probably a lot of stuff. Maybe that's back to the fact that we've got no healthcare facility, a proper inpatient healthcare facility in the prison. Yeah. But the expecting it to run and expecting to keep a decent regime for prisoners with so few staff, it's ludicrous.
Well, in terms of the regime which is now under the new governor, who's also the Director of Operations, you indicated that I think there's 50 additional staff that came from other units.
That's correct.
Which we were told things were improved dramatically, since the new governor. And you also indicated that the previous governor had requested that there be a redeployment from the likes of McGilligan and Hyde to Maghaberry, but that had been refused. Have you any understanding why he was refused? Because obviously, Mr. Ragg's not going to refuse himself.
Yes, exactly.
But have you any understanding why Mr. Cockwell, for example, was refusing to do something which the prison governors were obviously crying out for, and they have averted the very damaging report if he had?
Sorry.
The question was asked by one of our board members at a monthly meeting of April last year. The board member requested why, as in England, when some prisons fall short of staff and become problematic, that other officers are transferred from other places on short term, and we asked why could we not, because the situation was with not enough officers there, could we not take some from Maghaberry and take some from Hydebank in the meantime on short term notice, when we were told no, that it wasn't financially viable and that it just wouldn't happen. Now, that's in the minutes of our meeting, so it is.
Finances weren't available to...
Finances were not made available for it.
At times, it seemed as if, in fact, actually not just the previous governor, but the 2 of the previous governor were really being starved of resources, because the shortness of staff, the sick leaves, did not happen entirely on the last governor's watch. There were already, he inherited a prison that had high levels of sick leave. The VER was in full, progress at that stage. Yeah. And probably feel that he certainly wasn't treated fairly, and blamed for inadequacies that were not of his making.
You think that the report somewhat unjust on the previous governor and deputy governor who seemed to carry the can for everything?
Well, I mean, from our point of view, it doesn't matter who's governor. As long as we have a working relationship, there's no particular leaning towards any governor. As long as we can have a decent working relationship with them, whoever's governor is governor. But as we talked, we've got a current governor, then the previous governor who was held so much responsible for this bad report in May. He had previously been governor in Magilligan. Magilligan got an excellent report very shortly after he left. And it certainly wasn't down to whoever came in, because they only were in there a few months. So you have to assume that it's whatever he had in place that left Magilligan in the position. Yet he didn't get credit for what was done there, whereas the governor that was there during the inspection got promotion. He took over in Magarbry with a governor who was going out on VER and a deputy who got promotion. The staffing was already bad before they left. Yes, it may have got worse, but it was a knock-on effect. The more staff go off sick, the more pressure is put on the remaining. It's that sort of a domino effect, really. You know, so he didn't inherit a prison in a good spot.
Well, did headquarters deny them the tools to do the job on the ground?
We don't know that.
We don't know what went on between, but from what we can see, the staff
was short, so it was.
The staff weren't there, and he didn't get them, and they were fit to be found. I mean, 50 staff were fit to be found immediately. A new governor takes place. So I mean, I'm just to let you.
Our first indicator that there was a problem was when we asked for staff to be moved from Magilligan and Hydebank, and we were told that it really had nothing to do with us, for starter, which it didn't, but we were told that wasn't practical, and we knew then there was something wrong.
And your letter to Minister Ford, one that you sort of, whenever you were coming to the end of your period as Chair, Margaret, just from it here, several board members, myself included, witnessed the horrendous and very personal abuse and intimidation the staff in Roe House were subjected to some weeks ago, without any apparent repercussions for those involved. What did you witness?
One of our board members.
Are you comfortable with telling us what you witnessed?
Well, when Patsy and I visited that particular landing, and it was never physical, but it was very sustained name calling and very personalised name calling for young staff. You know, staff that were there, they were calling them all sorts, which I'm not repeating. One of our other board members that was last October, I think it was October the previous year, had been on the landing, and one of the staff there was very much intimidated by somebody, actually straight into his face. She was actually scared for him and actually went and stood beside him because there was no help of sort of coming anywhere else. And that officer actually has went off shortly after it's sick, is now medically retired.
Not one prisoner or more than one prisoner?
I think it was a couple. You know, and he actually said afterwards that he really thought it was going to become physical. It didn't, but he was certainly scared, and that was a common practice.
It's a common practice throughout the prison, so it is. And it was one of the things that was highlighted in the inspector's report, that the respect issue within the prison, across the prison, is non-existent, so it is. And there are a lot of work to be done on that end of it.
Okay, thanks for the meantime, Mr. Chairman.
Just in terms of your monthly minutes, your monthly meetings, are they in the public domain, or
No.
Would you have any issue sharing them with us, or would there be an issue there?
No problem.
Can't imagine anything. I mean, you're obviously going to have names, and we would obviously.
Well, if there's redactions that are required for whatever else, but it might be useful just in terms of our, information collecting.
Can't see any problem with them. Obviously, as you said, redaction. You know, because prisoner names and numbers and things like that,
of course,
and you don't want that out in the public domain.
Sammy?
Thank you, Chair. Thanks very much for your presentation so far. Apologies for having to nip out. So hope just a couple of quick questions. Hope I'm not replicating what other people have said. And I've read through your emails, and certainly you're seeing direct correlation between what you're saying and what the report's saying as well. Last year I was in Maghaberry, and I spoke to a number of prisoners, and I raised this with the prison authorities in terms of the lockdown. And prisoners just spend far too much time in their prisons. The very fact that you have said that there weren't enough prisoners on the land, or not enough officers on the landing. And also, Mark, you had said that things had improved because of the likes of 58 staff, additional staff. What would your perceptions be now of, first of all, the lockdown? Has that improved in that sense, in terms of it's not the problem that was, say, last year?
I think there's still too many lockdowns. It's trying to prisoners don't always object to lockdowns if they're predictable. It's the unpredictability. It's if something happens, the lockdown in Lantern, they don't get advance warning. And if they know they're going to be locked Tuesday and Thursday, they'll make the arrangements for their phone calls for the other days. They'll sort out anything they need to sort out. And prisoners, they will accept predictability. It's having planned to do something, make a phone call, whatever, and then suddenly that's taken away. That's what causes the tension. It's the unpredictability.
And again, another issue I raised was in terms of the staff morale, indeed the prisoners' morale, because very often they feed off one another. You know, if the officers are struggling, they're stressed, you know, the prisoners are going to be stressed as well, and vice versa. So at this point in time, how would you present staff and prisoner morale in Maghaberry at this point in time?
I think morale has got better, so it has. Well, since Phil Ragg has come along, some of the things that he has done has increased morale in it. A year ago, 18 months, every time we went into it, all we got was doom and gloom. This is a prison ready to blow, this is that. But we can see some semblance of morale being raised, and we can see prisoners now starting to talk about the core day, having more concern about what time of the day they're going to get fed at, and looking for more education. And just on a point of education, the courses in Maghaberry for work have been reduced, so prisoners are now looking to go on to work more so there, and that's another issue on it. But morale, to a point, still not good, but it's a lot better than it was.
You will often find, actually, prisoners will say to you, I wanted such a thing. Now, I know the staff are under pressure, and I would say, to be honest, for the last couple of years, it might sound strange to say it, but a lot of the time it has actually been down to nearly the goodwill of the prisoners that more things haven't happened. Prisoners actually recognise that the staff are short, you know, or I was to get that. Now, I know the staff are busy. I mean, we would frequently hear that from prisoners.
Yeah, one of the things I had raised was even things like Father's Day, where someone didn't get a card for a week later. Because they hadn't the staff to get through the mail and all that as well.
That's actually one thing. I don't know whether maybe you were here when I said that. It's pulling staff from one area impacts on another, and that is actually a typical example. You know, somebody with a birthday card. You mightn't worry too much about it outside. In there, it becomes a big thing.
Thanks very much. Thank you, Chair.
Thanks, Chair. I'm sorry I had to go out myself during your presentation. But in terms of we've been in the prisons ourselves from time to time, and lockdowns has always been an issue. Please believe that lockdowns have been too readily used within the system as an excuse by the regime.
It's not that we used as an it's just it's not the staff there. You know, if the staff aren't there, certainly the staff endeavour as much as is humanly possible to have as normal a regime as possible. And the staff don't particularly want lockdowns either, because, you know, as somebody said earlier, if you've happy prisoners, it makes life easier for the staff. It's not something that the staff relish.
But is staffing the issue that causes restrictions within the regime all the time? Is it staffing?
It is.
Because
Majority is.
if you go down to,
Into the staffing.
CSU, sometimes you can see staff standing on top of each other.
And the CSU,
It's a totally different.
it's a totally
different. The CSU is
thing.
totally different.
CSU has been closed down. The original CSU has been closed down because it wasn't fit for purpose, and it's something that we had highlighted over the years, that wasn't fit for purpose. And it was a small area, place, so it was. And I'm going to make the point here now, the CSU has been moved to Foyle, and it is not fit for purpose either. We have prisoners going through CSU and Foyle at the minute, and a building that's not fit for purpose for that type of restraint. You have prisoners who are in there long term, which is another problem as well too. The times that we find that there are prisoners in there long term in the CSU should not be, and there doesn't seem to be any exit plan for them prisoners, and there are 4 or 5 of them are on long term. They bring in other prisoners come in for things that they've done wrong in the prison, or they maybe come in with drugs or whatever. There are times when you get into the CSU, it's chaos with people who are coming down on drugs. But because of the long-term guys that are there, they suffer because of that too. I was in the CSU on Saturday. I do a lot on a Saturday, in the CSU on a Saturday, and every one of the people that I talked to in the CSU had been up from 4 o'clock, where 4 prisoners had decided to keep everybody awake. 4 prisoners were induced with something. What it was, I don't know. The CSU in itself is a problem in there. There's a new building for the CSU being done at the minute. We don't know the plans on it. We don't know what way it looks like. We don't know if it's going to be an improvement or whatever. But the CSU is definitely a problem in there at the moment too.
One of the things about the CSU needing maybe more staff is, by the very nature, the prisoners that you have in there are all in, apart from the few long-term ones who won't go anywhere else. And as the prisoners you have in there, they're in there because of volatile, because of broken rules somewhere else. So they're hard to manage anyhow. You've also got, and this is a big, big issue with us, so many prisoners end up in the CSU have severe mental health problems. And I mean, this bizarre behaviour, you know, I mean, you couldn't write the script for things that happen. You really couldn't. And if it does seem that there's more staff in the CSU, there's more staff needed because there is so much going on in there. And you know, it's one place that does need staffing.
So in your opinion, back to lockups, they're not readily used by the management?
The staff's not there.
I don't think so, because on that point, I've been to where Oaklands have been in the morning, and they've been for 10 minutes because they had to take staff from that land and lock it to go to another land where there was nobody there, and everybody's locked up. So I don't. That instance there showed me that there was a lack of staff. There was no staff, so I had to lock down some prisoners to open up another house. So it's lack of staff, and I don't think there's any ploy or anything else on there. It's lack of staff.
Yeah, but sometimes that we have been and we have felt that has been too readily used.
It certainly would not be the impression that I would get, you know, that lockdowns are used. It's just staffing. Say, I know your perception of more staff in CSU. More staff are needed in there, and to be honest, it is a very challenged environment to work in.
Staff in the CSU have a very, very hard job. It's a job I couldn't do. You have the funny thing that some prisoners that go to the CSU, I'll tell you, I don't want to come out of the CSU again. Why not? Because I'm getting opened up, I'm allowed out to the yard, I'm getting a shower swam, I get a nurse recreation later on, and I'm getting some form of, I'm allowed on the telephone to my wife, I'm getting a better regime in here, and I would say that you're getting a better regime in the CSU, I'm getting a better regime than I'm getting in Ban House or in other houses. Now, I have to put my hands up and say, all the time I've been in there, the A&B and McGabry, we have a standard thing where ourselves, that somebody from whoever's on rota does the full round of the CSU at least once a week. You're in the CSU nearly every day, but one person on rota will do everybody that's on, and the line is when they open the door, are you okay? Do you need anything? Or what's going on? So the CSU is a place that we being all that, so we do. But this move to the new, until the new building's ready, is not a good move. Royal House is not really good for it, and if it's going to be any longer than 6 months, somebody will need to take a look at the situation.
Thank you very much. I mean, other members have said it, but it has been a refreshingly honest session, and I think you've actually highlighted more general, wider issues about the prison population. And I think there is little sympathy at times from the public about how prisoners are treated, but actually, we need to take it seriously, because there's an impact on the safety of prison staff when prisoners aren't treated properly. If we really want them to come out as changed characters and try to build a constructive lives for themselves, we do need to invest in them, particularly around healthcare. And I really appreciate the comments you've made about the healthcare, because I think it's really, really important. And the issue of a core day and establishing a routine makes life easier for prisoners, makes life easier for prison officers, and allows that regime to be normalised. So I really do appreciate the remarks you've made and how you've answered the questions. I'm going to follow up on a couple of things Paul had asked around why you're not getting a response to your reports. We'll follow up with that and ask the prison service on that, and around the phone calls and why you're not always being alerted to incidents that are happening. We'll follow up on that as well. The committee staff will not like this, so I'm glad it's far away from Christmas, but what I'm going to do is ask them to collate all the information that we have had and try to establish a timeline of events, because you've very helpfully given us a timeline of communications you've had with both the prison service and with the Minister. We've also had a number of statements in the House which perhaps conflict with some of that information. We've had a number of evidence sessions as well, and where we've highlighted incidents at different times. So I'm going to get the committee staff to try to collate a timeline for us and see where those discrepancies are, because we're hearing so many different versions of events from different people that I think it would be useful for us to do that. So look, thank you very much. It was a lengthy enough session for you, and I really appreciate you coming and spending time with us. So thank you very much.
Thank you.
Okay, members, I know people are going to start to drift away, so we need to keep our 5 to make decisions here. So I'll try to get through the rest of the agenda as quickly and as efficiently as possible, with your help, obviously. Agenda item 8 then, can I refer members to page 461 of your packs. Members will recall at the meeting on the 19th of November that the committee agreed it was content with the proposal for a statutory rule to allow the courts in Northern Ireland to make slavery and trafficking prevention orders in respect of individuals who have been convicted of slavery or human trafficking offences in other jurisdictions within the UK. The statutory rule will also give the courts in Northern Ireland the power to enforce breaches in this jurisdiction of equivalent or similar orders which have been made by the courts in other jurisdictions within the United Kingdom. The statutory rule was laid by the Department on the 13th of January. It is subject to the draft affirmative procedure, and there have been no changes to the policy content since the SR1 was considered by the committee, and the examiner has confirmed there's no issues to raise with regards to the technical aspects of the rule. The SR is scheduled for debate in plenary on Monday the 8th of February, and as soon as the rule is made, the Department can commence the legislation in full. At that stage, the rule will take effect. So can I ask the committee, are we content with the statute rule? And I'll put the question formally that the Committee for Justice considered draft statute rule SR, the human trafficking and exploitation amendment of slavery or trafficking offences and relevant UK orders, Order Northern Ireland 2016, and recommends that it be affirmed by the Assembly. We agreed?
Agreed.
Okay, agenda items 9, 10 and 11 are draft statutory rules relating to the Proceeds of Crime Act. Page 470 to 632. At our meeting on the 3rd of December, we agreed that we were content with 3 proposed statute rules to bring into operation Northern Ireland Codes of Practice under the Proceeds of Crime Act 2002, relating to cash searches, investigations and search, seizure and detention of property. The first such rule will bring into operation the Recovery of Cash Search Powers Code, which provides guidance to constables and accredited financial investigators in operation of the powers to search for cash where there are reasonable grounds for suspecting its recoverable property or intended for use in unlawful conduct. The secondary SR will bring into operation the Investigations Code, which provides guidance on the exercise of the investigation powers under Part 8 of POCA for confiscation investigations, detained cash investigations and money laundering investigations. And the third such rule will bring into operation the Search, Seizure and Detention of Property Code, which provides guidance to constables and accredited financial investigators about exercising the powers to search and seize and detain property, and details the approval, recording and reporting requirements. The 3 SRs were laid by the Department on the 15th of January. Subject to the draft affirmative procedure, no changes to the policy content since those were considered by the committee, and the examiners confirmed there's no issues to raise either. They're scheduled for debate on Tuesday the 16th of February, and it's proposed that all three will come into operation the 1st of March 2016. So look, I'll go through and put the questions on them separately. So on the first one then, can I ask if the committee is content that the committee has considered draft statute rule, the Proceeds of Crime Act 2002, Cash Searches Code of Practice Order 2016, and recommends that it be affirmed by the Assembly? Great. Second one then, that the Committee for Justice considered draft statute rule, the Proceeds of Crime Act 2002, Investigations Code of Practice Order 2016, and recommends that it be affirmed by the Assembly. Great. And finally then, that the Committee for Justice considered draft statute rule, the Proceeds of Crime Act 2002, Search, Seizure and Detention of Property Code of Practice Order 2016, and recommends that it be affirmed by the Assembly. Great. Thank you, members. Agenda item 12 then, referring to page 634. Just to remind the committee, the department is responsible for setting the fixed amount of bereavement damages under the 1977 order. Following representations by the Association of Personal Injury Lawyers, that we had raised the issue of the level of bereavement damages in Northern Ireland and what consideration the department had given increasing the level to bring it in line with England and Wales. The department advised of its intention to consult on the issue. The committee considered the department's draft consultation document at the meeting on the 24th of September, and we agreed that we were content with the consultation to take place, and then we would consider it further once that was complete. The department has now provided a summary of the responses it received, which all support increasing the level of bereavement damages, whilst the majority supported aligning the rate with the fixed level in England and Wales. The department is proposing to increase the level of bereavement changes in line with inflation as measured by the CPI, rounded to the nearest £100. So this will increase the award to £14,400 based on the CPI from November 2015. The department is also proposing to adjust the rate every 3 years. The change will require negative resolution statute rules. So, member, are we content then with the department's proposal? Great. Okay, thank you very much. Agenda 13 then, page 695 your packs. Part 3 and Schedule 2 of the Modern Slavery Act make provision for new maritime enforcement powers, which extend to Northern Ireland following the passing of a legislative consent motion by the Assembly on the 8th of December 2014. The department is required to prepare and issue a code in respect of practice to be followed by Northern Ireland constables and enforcement officers when exercising the power of arrest when they have reasonable grounds to suspect that a slavery or human trafficking offence has been committed on the vessel under investigation. The department has provided the draft code of practice for Northern Ireland, which has been informed by a public consultation exercise and engagement with the relevant statutory authorities. It draws on Pace Code C, which deals with the detention, treatment, and questioning of persons by police officers. It's also broadly consistent with the equivalent draft code in England and Wales, and a negative resolution order will be required to commence the code. So are we content to note the draft code of practice? Yep, great, thank you. Agenda 14, page 733. The department intends to undertake a public consultation on the creation of a specific offence of domestic abuse and a domestic violence disclosure scheme, often referred to as Clare's Law. The department has provided the draft consultation document and results of its initial equality screening of the policies. Consultation will seek views on whether a specific offence should be created that captures patterns of coercive and controlling behaviour in intimate relationships, and on a suitable disclosure scheme where the public have a right to know or right to ask, or whether current arrangements under existing legislation are sufficient. Are members content for the proposed consultation on a new new offence of domestic abuse and of domestic violence disclosure schemes to take place? Agreed. Okay. Then in correspondence, there are 14 items of correspondence, pages 839. Let me see, just raise a few of them. Item 3 of correspondence is an initial response from the department following the High Court ruling on abortion law. A further update was received today and has been tabled. And obviously there's ongoing legal action there, but it's just really for noting. Item 5, page 853, is correspondence from the department providing the latest update on Access NI and PSNI performance in relation to enhanced checks. The update indicates that they're now consistently exceeding the public performance target, and the percentage of enhanced checks issued within both 14 and 28 days remains at a high level. There's also been a further significant reduction in the total number of outstanding checks to PSNI, and in particular there's been another major improvement in those checks that have been delayed for over 60 days. It's worth reminding us that the committee had considered this issue back in June 2015, and we asked at that stage for monthly reports, and I think that has proved to be successful. So I would just really for noting, but I think it's been a useful exercise in those monthly reports, and I would imagine that the next mandate the committee will want to continue to do that. Item 10, page 911, is an invitation from the Attorney-General to a seminar on the 11th of February on effective responses to antisocial behaviour and a discussion of current law and practice. Now, that's the day that some committee members will be going to the Glasgow Drugs Court, but others who may not be attending that, if they want to go along, please just advise Christine or somebody in the committee office if you want to go to that. Page 11 is an invitation from the Police Federation to the official launch of We Are You. It's a new initiative designed to demonstrate how police officers are no different from the public they serve. That's in the Long Gallery on Tuesday the 1st of March. I've said I'll go along to that. If anybody else wants to go along to it, they can get information from the committee office. Any other items of correspondence that anybody wants to highlight? If not, then Chairman's business. Don't have anything of any note. Any other business from members? Okay, and the next meeting is Thursday the 4th of February, 3 p.m. in room 30, and don't forget we have our Justice Innovation Seminar with the Attorney-General before that. He's looking at whether excessive penalisation is a problem. That's at 1:30 in the Senate chamber, and please encourage members to come along to that if they can. Okay.
This is the Northern Ireland Assembly Committee Room 30.